ಸರ್ ವೇಸಿಲಿರೋ ಕೇಳುತ್ತಾ?
ಕೇಳ್ತಾ ಇದೆ ಸರ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
ஐயோ ராமச்சந்திரா, இந்த கேஸ் நீ நடக்க நான் நடக்க விடுவேன். அதானே
இன்னும் ரீச் ஆகிருக்குல்ல சார்.
Remove for when do you want? When do you want? Huh? Seventh. September. Tomorrow. What? Day after. Yeah. Yes. In the what? It's centrality. Only to look at. Respondent 5A to C. What about 3, Mr. 3 you are taken publication, right? Mark because Learned Council undertakes to file wakalat on behalf of legal representatives of disease respondent. Has already filed, right? Has already Mr. Swans has already filed wakalat on behalf of last of respondent number 5. They are duly served and undertakes to file wakalat on behalf of LRs of disease respondent number 7. This is within how much time? What is this? The IA LRs of IA2 of 20 scientifically supported allowed mandate I think we filed. Before that you write what about the 3 IA
7. Please in this particular number.
reason of such so and so IA so and it amended cost at 5 visit which Mr. Notice issued to LRs of respond number 3 in Delhi. What the Prabha, which edition? 4 edition. On which dated 5/8/2022 is accepted in the results ISO and service results to be submission. Then they said lastly amended cost and will be filed within 1. In order with only country. Number 2. 9 and 10. And 12. Council for the petitioner submits that he believes that the requirement of filing serving the respond number 10 and 12 we discussed with the the aforesaid submission is allowed. However, if the consequences of non-service non-service on this report 10 and 12 shall be considered at the time of hearing of enforcement. Yes, all right. That you have that order enforcement, right? Who will carry out give that order? Will carry out spot inspection. The public interest litigation has been filed. It in the nature of matter to 1 to 9 to make spot inspection and to survey the land in survey number 10 of so village Nigeri Hopri, Bangalore South Taluk, and to resume the land stroke property of which respond number 7 has executed solely over and above the saleable area. At that order. Respondent number, who will cause an but they will who will cause an inquiry? Deputy Commissioner. Bangalore South shall conduct an inquiry if Bangalore Deputy Commissioner Bangalore South has any difficulty, then they request whom to request to provide police assistance. Who will provide concerned police station to provide police station? It in time notified by Deputy Commissioner. Any orders passed by Deputy Commissioner. Action taken report shall be filed before this court before 2nd of November 2020.
I thought only member in all the prayer. So in terms of that memorandum represented by the petitioner, it is for we can get dispose of the matter.
It is disposed of.
See, disposed of.
Questions are over, right? You want the to be disposed of. Okay. Dispose of. Rectification of further orders.
My lords, may I mention item number 35? If court permits. Item number 35, my lords. I have some urgency, my lords, and I want to seek time for filing reply. The state has filed some application, my lords.
Which court you are appearing, Mr.? How many years of this?
Sir, 1 year, my lords. My apologies, my lords. I
No,
was in
no,
some
need
urgency.
to what's your name? What's your name? Item number 3 is going
Sir,
on.
Lord Saurabh
Council
Singh.
is making submission, and this is interference through video conferencing. Doesn't say anything. So tell us
My
how much.
sincere
what
apologies.
punishment- What's your name and address? Tell us. Name and address.
Uh,
We are issuing
Millet,
bailable
sorry,
warrant.
sorry, Millet, sorry,
Non-bailable warrant. No,
my,
no.
my,
There's
my
nothing.
humble apologies. My humble
What's your name?
apologies, Millet.
What's your name?
My humble apologies,
Say,
Millet.
what is your name?
Sir, Saurabh Singh, Millet. I'm really sorry, Millet. Sorry,
Okay.
sorry. My mother
What is
was
your
admitted
address? Address, or we shall find out from Bar Council.
Millet. My mother is admitted in hospital. That's why I interfered. I'm really sorry, Millet.
Will
I'm
you
really
appear?
sorry.
Or
Yes,
should we
Millet.
issue bailable warrant?
Millets, I will appear Millets and
When will you appear?
Millets,
When
I'm
will you
really
appear?
sorry. Millets, I live in Delhi.
Item
Millets,
number
please,
3 is
Millets.
going on.
Sorry,
And
Millets, sorry.
don't, Mr. Young man, don't do like this.
Sorry,
This is
Millets.
not
Sorry, Millets. I have just 1
nothing.
year of experience, Millets. I'm really sorry, Millets.
That doesn't mean that you should start dancing in the courtroom.
Sorry, Millets. Sorry.
That
My
I
humble
did not know that it is prohibited to dance in the courtroom. Therefore, I am dancing. That doesn't mean
Sorry,
nothing.
Millets. Sorry, Millets. I'm really humble
So
apologies.
this is
Millets,
unfair,
please.
Mr. Patel. You should take action against these people. See, item number 3 is going on. He is interrupting us and seeking an adjournment in item 34. So what is this? Everybody comes here after enrollment and starts behaving like
Sorry.
this. Some
Sorry,
sanctity
Millets.
has. No. So tell us how much punishment for contempt. File an
Sir,
affidavit.
Sir, my humble apologies, Millets.
You show
Please
cause.
consider.
We will punish you. Punish you.
No,
You show cause.
please,
Ah,
Millets, please.
File an affidavit.
I am begging you, Millets, please.
No,
I'm begging you,
there is
Millets.
no question of Mr. This is not an
Millets,
informal question.
Millets,
It's not a question of peace.
Millets,
Nothing.
Millets, my mother is admitted in hospital, Millets. That's why, please consider my request.
Mute him, Mr. What are you? I mean, you are also enjoying this along with him, Mr. Nataraj. Then you should control this. I mean, that he has no right to disturb the proceeding of the court. And he doesn't want to argue the case. He only wants an adjournment. Otherwise, also we adjourn. There's nothing great about what he wants to do. And you issue him notice. Mr. Notice is being issued to you, file reply, and you will be punished for contempt. Yes. What is it? So this is, what is it, Mr.
Item number 3.
What office objections on IA? Comply. Dear counsel for the applicant submits that office of outside statement same is ignored. What is it then? Send it. Let the appeal be listed for orders on admission on.
Not immediately for consideration of.
Oh, let the appeal because let the on IA 2 of 21 on 12 September.
Therefore, in the case,
We have said already. No, this is not that I mean like you are being magnanimous enough in telling that SLP has been dismissed. So what should we do about it? No. Last time also you made this statement. SLP dismissed. Be happy about it. Go to International Court of Justice. Last time also. 29/7/2022, you owe same submission initiated for process of identifying this thing, same thing.
You don't want to use that also.
So, Mr., what should be done? Who is the person?
Which officer?
Who has given permission? So shall we issue non-variable warrant or variable, or you will keep him present? All learned counsel is directed to submit compliance report, failing which appropriate orders. This was 1 month time. 1 month ago, we had granted time. You have not done anything. Because this petition has been filed for non-compliance of the directions contained in the order dated 2nd of July 2021, passed by the learned civil. On the last date of hearing, that is last date of hearing, that is on 18/8/2022, learned respondent submitted that the SLP filed by the Bangalore Development Authority has been dismissed on 29/7/2022. Thereafter, therefore, this court directed the respondents to submit compliance report, failing which it was directed that appropriate orders shall be passed. Line below. When the matter is called today, have not been produced, nor any justification has been furnished for non-compliance of the directions. Non-compliance of the directions contained in the order dated 2nd of July 2021, which has already been upheld by the Supreme Court. Here, Commissioner, Bangalore Development Authority. Therefore, it is directed that Commissioner, Bangalore Development Authority shall remain present before this court next week on 14th of September 2020. Learned Counsel undertakes that assures this court that so and so shall remain present before this court on 14/9. That's all. Said, direct shall remain present on the next date of hearing. Then say he assures that no, he will remain present or not. You are not sure. No, that's forget. We have passed an order, right? No explanation, nothing. Just like standing up, saying, thinking that we will not read it. Same statement you made. No, we are not asking you for anything. We ask you whether that's all right. Late available warranty is sum of rupees 10,000. We should to secure the presence of whatever. Delete that he assures that he will remain present. Then you are not saying anything. We are asking you. Let it be issued. Why should we take the trouble? Available warrant 10,000. We should. Don't tell them that this court cannot do anything and I am there. I will protect. Everybody is bound by the orders passed by this court. Don't behave like an officer of the court and tell them that they will have to suffer consequences. They cannot take this court lightly. Just like that. How casually you are telling 1 month ago you made the similar submission, SLP has been dismissed. Today also you are saying SLP is dismissed. What have you done from 12/8 till 5/9? What have you done? No explanation. It will someday, somewhere, we will have to take an action. Perhaps our magnanimity in exercising, you are taking things for granted.
Filed by the BDA is also posted today on as against the direction given by the Secretary.
He will tell all this. Not a way to argue. And after seeking instructions in the courtroom, and after the order is passed, then telling you should have filed it. Fine. I think now bailable warrant is issued now. If it doesn't appear, we will see what is to be done. Fine. Next. Okay. It's late now. We were asking you that few minutes ago. You did not respond. Yes.
So 5, other item.
Not appear.
And six, R. Subramanian, never say, dustbin.
Done. That's it. That should be enough. We'll direct them to do it within 2 weeks now. Correct. Some difficulty, right? Also, you do it within 2 weeks, right? Whatever. How many? Oh, so transfer deed. Rent means what? We don't. What? How much time do you want them? Just tell us. This transfer deed has to be executed. Petitioners, it is to be executed by the petitioner. It's just petitioner execute the transfer deed under protest order. For you. Municipal corporation.
Yes,
You are
yes.
municipal corporation.
Yes,
Yes.
The road, belong to the
Why it is not being executed? Tell us any ground. I mean,
yeah, yeah.
why don't you? Why are you not? Hey, we remember. Yes, this plea you have been taken. I will do it tomorrow. This thing and this is pending. No, no. Why you execute the transfer deed? Or to do it tomorrow. What the problem?
Who has made an application for transfer? Who has made? Why did you make an application for transfer of 23 guntas then? No, for the purpose of compliance of this order, you should have sought for only 8 guntas. He is making a statement that if you file an application for 8 guntas, they could have made. You have made that application for 23 guntas. Whoever you are required to comply the order. Yes. Trying to play smart with the court. Comply it all, we will issue orders against you. Yes.
No,
Then we'll-
saying that
we'll-
prepared to do and not doing it, right? That's why we understood that last date of let them remain present, all of them.
Yes,
Ah,
yes.
they will. Again, they will remain present. No, don't try to play smart with it. No.
Make necessary application. You have made application for 23 guntas.
That's the question.
There's nothing called something, Mr. Please give the date. There is nothing called something. You just now said you have made the application.
Call. They will tell us. Yes, mark the presence. Despite indulgence being shown in this contempt petition, respondents complied directions issued by this court of even the land measuring 8.5 guntas was required to be transferred, the respondent 178 made an application in respect of made an application in respect of 23 guntas of land. Full stop. The conduct of just a minute, don't interrupt now. Full stop. It appears that 128 somehow want to delay the execution of the orders. By order dated 25th January 2020. It's 128. Remain present before this court. On 19th of September 2022, along with an explanation. No, we thought that you are genuine. You are not, no. Fine. Yeah. Also responded to or everything except one number. You are responsible. Counselor, who are not properly advising them. No. Answer, my lords, very simple. If it's 8.5 guntas, why you did made an application for 23 guntas? No, and waiting for the case to be called up and then orally telling you if what you are correct, filed an affidavit beforehand saying that, sir, I had made an application. They have returned my application. They are not accepting. This you should have said on affidavit beforehand. That shows your conduct. No, fine. No.
Oh, now we have fixed a date. On the next date, you can come.
No, and explain your conduct. Doing all this. Fine. We don't. Because of you, there is a direction to still not satisfied. What do you want? Non-available warrant. What do you want? Then, so if you should have advised them that this is a contempt proceeding. Don't take things lightly. You should have filed if they are saying, you should have filed an affidavit immediately that I had submitted an application for 8.5 guntas. They are refusing to accept. So and so officer is refusing to accept that affidavit. You are not filed. Already you are making a statement. Then you said it was filed long ago. Then you said that they refused to accept it. You realize what you are saying. Because we are dispassionately, we are hearing, so therefore we know. It's not that we want to meet your clients, therefore we have called them. Because if what we are telling is that your clients will appear because of submissions made by you. You said that, no, absolutely, you should feel sorry about it. Sorry about that. You said that we submitted an application long ago. Then you said they refused to accept it. You don't know what date. My lord asked you the date. You are unable to give some time. What did you say? Some time. Then my lord said, sometime can't happen. That means you are taking these contempt proceedings absolutely casually. Rest assured that nothing will happen. You tell them better that from that day on, they may not return home. Tell them. You don't understand if we are not shouting, and only by shouting you understand that, oh, it's serious. Court is not shouting, court is just telling like this, so I can carry on. Everybody, including us, we are bound by orders of this court. Sanctity of this court is the foremost thing, and everybody, including us, we can also sitting here commit contempt of this court, right? So you are appearing for accused person in a contempt proceeding, such a callous and reckless attitude. What alone will help your clients? Okay.
Very good, Ryan. Want me to look at?
Okay. Counsel correspondent treatment is granted. Thank you. We enable her to file affidavit of compliance.
Right? Kevin, nothing more.
After compliance has been reported, in this manner, the claim has been brought on previous.
Yes, madam. It takes to file the status or list in the next week. So, madam, say next week that I will file it today. Cases are listed not for adjournment, right? Cases are listed so that we can decide. Every day you will say, I will file it today. I will this thing. So file it tomorrow.
Right?
And the letter of credit will also be opened in our.
Right.
Consideration, the judgment of 2nd December.
Complaint. What?
This complied one.
Complaint. There should be no issue, right?
Yes.
You should be able to make a statement that it is complied with. Simple. Then what however? Nothing. However is another writ petition. Right? However, if you are not happy, another writ petition. File it. We are open 5 days a week. And at some time Saturday also. Market presence. This petition filed for non-compliance of the judgment dated 2/12/2020, order dated 2/12/2021, number 5368/2020. And it counsel for the parties jointly submit that the actions contained in the opposite order applied with stop in view of which of submission we are not applying to 50. How it attempt proceeding. But is reserved to the petitioner to take recourse to such remedy as may be available to it in law in case grievance of the petitioner is still survived.
They were scheduled to visit
But that those contempt petitions also. It's not, madam. After arguing some contempt petition, you cannot. What do you listing? You want a listing of the case. You only tell whenever your number is called, or ask Mr. Mahindra what should you do. Mr. Mahindra, please guide her what she should do for listing of a case. Tell her. Ask him. Ask him. He will guide you. Right? Don't ask everything to us. What is she thing? What? Chetan, you also contact Mr. Mahindra, right? He will advise both of you. Ask. We would have never become judges had we known this fact that life is very easy. You just ask the judge to do anything. He will do everything. He will answer you. He will decide your case. He will go through the files, decide the case, pass an order, speaking order. Thereafter, tell you if a case is not listed, what to do. He'll tell you. Ask the judge that it be listed next week. The judge will say either yes or no. So be happy. Don't do anything. If you don't know, unfortunate that these you young lawyers do not know what to do when you want to get a case listed. What should you do? Have you heard of anything like memo? Memo for mentioning, have you heard? Then what should you do? Who was instructed? Who instructed? We told you. Huh? Then who told? Who told? Where is your mention memo? So what is the lesson? Lesson is lesson is not to rely on the court staff and to interact. Mention the memo means what? You are behaving like, it's really strange. That young man, item number 3 was going on. He interrupts from video conferencing, says that 34, item 34, I want a week's time. Here in your contempt petition, without mentioning a memo, case is not listed. You are telling us that it should be listed next week. See, Mr. You may not have any responsibility. You don't feel like owing anything to this court. But our problem is that consistency. Today, if we do it in your case, in every other case, oral mentioning, whatever time, very good. Very good. When you argue a case and thereafter say 2 other cases be listed next week, then whole mention memo should be, practice should be dispensed with. No need of mention memo. Anytime any lawyer like Mr. Mahindra is appearing now in item number 10, he will say 2 other cases be listed next week. 2 years. How many? Constitutionally eligible to become a judge of this court. Realize? You realize, right? Only 10 years of practice is required. Madam, how many years? Good enough. 12 years you have only known this. No, 12 years you have only known this, that if court staff tells you something, you should rely. People, we are trying to explain it to you. You think that it is such a simple thing, judge is giving us a lecture. Why we are giving you a lecture? Because we are trying to explain that why we can't do it. So then Mr. Mahindra will say item number 10, 2 other appeals be listed next week. Then every case they will say 1 case be listed next week. You can't do it. It has to be consistent. In fact, we are trying to explain it to you. You seem to be okay and happy with this idea. We have to, unfortunately, we are put in the document, we are trying to explain it to you that why it can't be done. Enough, right? better things, right? You understand?
Government educate.
Science, yes, madam. Where? Oh, today you have filed, right, madam? Applied. See, madam. See. Come. Wait to. Why should wait till we say? No. Shall we say that don't? Are you not under an obligation to supply? Then why should you ask? Shall I give you? Consider and this thing carry out Kodi and Durasti proceeding 6 months. Done. Which read it, madam. Again, it will go. We will sign the order sheet. Somebody will take it now. This so that on account of heavy rains, there is no place to keep the records. So it will get wet also. So see, read it, para 5. Read it. Your own time. Completed 4D and Durasti work. New survey number has been assigned. Para 5. Para 6. Read it. You will have to challenge it, right?
It has to be 22 only, madam. It's a typographical mistake. Your order is passed in year 2021. They have not rejected one survey number. They have carried on the Kodi and Duras. Another they have refused and given even endorsement. If you are agreed, you have to question it. They have given reasons why they cannot do.
What? So yes. Of the petition has been filed on same 8th of September 21. Disposed of the liberty to. And which 2 other cases are listed next week? Mr. S.S. Mandralane. Praise for is granted a week's time. No, praise for adjournment to enable him to prepare the case and argue the same list after 1 week. Yes.
Government educate.
The school decided to shut after. Arrears of salary and other emoluments that were as per revised pay scale salary earlier. He will have action benefit. He because the initial law of this, he is also.
Filed their appeal. They have not filed their appeal. No, not filed.
Not
You have
filed
not filed the affidavit.
We are hearing her. It's 1 week's time. I don't have to.
Getting the. Slightly workforce.
Ah,
In the sense of, what are the present? Take charge. But is- Change the narrative nature.
what is to be done?
But the sum of
This object.
3 days. The server copies on the.
Some office object. There are so many. Of these comply. We'll take it up after what next week?
Next week.
Huh? Or the president. Oh.
Next
No
week.
need counsel for the applicant undertakes to comply with office objections and to effect justice service on which respondent, Mr. On private respondents within next 3 days. Interim order shall continue till next date of hearing, this on 12th of September. Ah, you told us. Like to the other side. Sir, what happened?
Condition we have stated for compliance, but it is not the compliance of the, this is not position, anything.
You got her or go on? You got her filed? Or? Maybe not. Hey, what is the order? Interim.
When have you filed?
Not there. And the counsel for the petitioner submits that he has filed a counter affidavit on 3rd of September 2022. However, same is not on record. Office is directed to place this same and place it on record list in the next week.
50, is that David?
Thank you. Granted.
The 15, where they go like.
Yes. Hilda. Yes, madam. Long 58. orders are waiting. Yes. Fine. Consider now.
Waiting, hearing and hear, finish
Yes. No orders are required to pass on IA4 as the appeal is already listed for hearing. No orders are required to be passed on IA4 of 22. The same is disposed of. IA1 of 22 requirement of this thing differently. And 3 also limitation, therefore no orders are required to be passed. Yes. So we'll list it on admission or admission. What is it? What? Dismissing the appeal. Huh? Dismissing the appeal. Oh.
Arising from the same order.
Yeah. 3 months my nothing else. Nothing short. 6 months time is granted. We'll grant you 6 months time. No, but the other side is not here. In that case, other side was heard, right? But we can grant 6 months.
Connected
6
matter
months.
already.
This.
From today, he wants 3 months.
3 months.
You want 3 months time? So, same one.
Starting in 6, we should grant him 6 months. No, why are we saying 3 months? Fine, 3 months. This intra-court appeal has been filed against order 28 January 2022. Passed by Learned Single Judge in WP number 18441/2014. The applicant fairly submits that a similar writ appeal arising from the same judgment has been disposed of. In support of opposite submission, 15th of March, it passed in WA number 200/2022 has been placed on record. Paragraph 40. Signed in recent judgment with the view to maintain parity, the impugned order dated 28/1/2022 in WP number 18441/2014 is modified, and the appellant is granted time up to 3 months each. 6th September.
End of November.
On or before 5th December. 5th December 2022 to quit, deliver and hand over the vacant position of the premises in question in favor of respondent bank. The appellant shall file same thing, right? Undertaking and all that. Right?
You want time? We are not.
Oh, so fairly submits that covered by, he has placed on record copy of judgment, right? Then you say that he further submits that the appellant be granted 3 months time. We get the conditions, right? Accordingly, the appeal is disposed of subject to following conditions. 1, 2, 3, 4, 5. Judgment is modified and appeal is disposed. Same order.
20, we use here.
Huh? What?
Fault. I use it.
21, I clear.
Then IA2 is not.
Appear for the appellant, my lord. My lord, it was, my lord, for non-compliance, my lord, was rejected on 24th August. 10 days back, it was rejected, my lord. I made an application to recall.
15 minutes. We know that. It is, you are not pressing that application.
My lord, 24th August, my lord, before the honorable.
Happens that the application for recall is entertained, the appeal on very day is restored, that very day is allowed with cost of 20 lakhs. Does it happen like that? It has, today it has been restored, right? Thereafter the appeal will come up, no? Why do you want that appeal the delay should be controlled, appeal should be heard today, it should be allowed 20 lakhs? How? No, huh? Condonation in the finding application for recall. See, Mr. Huh?
Made application for restoration.
Just a minute. Application delay in recall, right?
No, 24th August, my lord, that was, there is no
Hmm.
delay as far as I
New. New.
Calling the RD. Third April.
Recall. He didn't recall. He says that he has filed application in appeal. That's what he's that he should allow delay in filing appeal.
Is there any delay in filing the appeal?
No, my lord, writ appeal is filed in time. Serial number 21.
Yeah, serial number 20, sir. Please wait, sir.
I'm sorry. My
You are being muted and you again and again unmute that.
He has not mentioned the delay.
The application for recall. So where is the question of condonation of delay arises? Appeal is not listed technically.
Not pressed. It has mentioned not pressing. He says not pressing is not correct. That's a. We are
So
pressing.
we have only passed an order on IA1 of 22. Mr. This is where you should argue, you will seek adjustment. I think you will argue. IA1 of called WA restored.
21, in our clear.
I'm sorry, my lord, there's some confusion. I'm sorry. 21, my lord, writ appeal is filed in time, but it is rejected for non-compliance. I pray for restoration, my lord.
For reasons assigned in the IA, duly supported by an affidavit, IA1 of 2022 is announced. In the result, IA number, WA number 501/2020.
Published.
Petition. Since the contempt has been placed in respect of an order, repetition, no orders are required to be passed on IA 1 of 2022. Same is this code. What is the non-compliance? Huh? Best to respondent 1 and 2.
23.
Station IA is allowed. Issue notice of IA 2 of 22, 3 of 22. That act 7. 7.
Before, it was के
24, 25, 26. The reasons assigned it have duly supported by one of the 2013 in order 25, 26.
Serial number 27, I appear for petition on this matter.
What do you say? Amendment. Oh, yes, Mr. Bain.
Short for deletion of one line.
Or an IA 1 of 20. To count the nature of proposed amendment and all the reasons stated therein. Comma same is allowed. Let amended petition be filed within
1 week minutes. Much obliged.
Petition number 28, Srimati Sumana Naga, CH-2. Petition of CH-2. It's not why the matter is back. Some. 25124. The requested law. Direction was given by the Honorable Bench. Requesting the Chief Secretary to hold. That's not an inquiry.
this is to be heard, right?
We can.
Regarding maintainability.
Maintainability. Yes. We'll take it up. This thing, end of motion hearing cases so that others do not wait. Take some time, right?
Here, what was there in the file? Where is it? Yesterday.
Yesterday, are you? That new blue file. The question is.
29%. ये चलना करेगा.
BP 5.
The purchase of land. Let me proceed. Now, the three different types. Who either purchase the property from the tenant after the expiry of the 15 years. But form the layout, the extent of. Second.
Waiting is 10:30. Which case? Because this is waiting is 10:30.
Hearing cases.
Yes, yes.
Have purchased the land, you know, that have formed the layout in the extent of. And I will. So, you know, what happened, here people see, there is information that the point is sued for recovery of. Point number 3, this was a very same property. Limit of fee expired, and thereafter hand over the vacant property. But what had happened, then I have made an application for a certificate copy of the order, because I could not have any access to the paper. So I requested the paper, so it will not be given, certificate copy will not be given. I requested the form number 3 to provide it in sort of time, and then we provided it, and thereafter I was given certificate copy of the order finding. Long to repeat it. But even also another way, keeping conservation. In one portion of the introduction to 1981, all the all part time the land was contained occupancy rate in the 2002. And the response number 3, I will create the year 2005. That is after a lapse of more than for 24 years. There is no fixed to sell the property. He thought the property converted and sold it to 2% in the year 2005. In the year 2005, thereafter 2% of sold it to some other person. Yet people will sit and thereafter you purchase the property. What set of whether you are going to purchase of the property or not. How you will always about the it doesn't matter. Because in the year 2016, actually responding to it, being the they filed the requisition challenging order 20% 1981, 85 came with and thereafter that again granted the where is that is on 30th November 2021. Requisition came to be allowed and all of a sudden, the respondent was taken.
When have you purchased the property? When have you purchased the property? 2006. When was the initial first order granted to the?
First order granted 21/10/1981.
1981.
Order,
That was questioned in a writ petition in 83.
yes.
Yes.
It was questioned in the-
When was that writ petition disposed of?
We had no knowledge about it.
Whether you had no notice or that is a different aspect. When was that writ petition disposed of? 1983.
Why?
85. That was as on the date of purchase, your vendor had no title.
Yes, well, that's the one number 7.
As on the date of your purchase, he had no title because occupancy right was not granted to him. The order was
At
crushed.
the date of purchase, there was a title.
How?
fewer, because two was another odd part. in favor of-
Then within the period of 15 years, you have purchased it. 2002 was the grant.
Yes, 2002.
Yes, 15 years non-alienation period is there.
What has happened? So two or was not actually within our knowledge. We thought that 31/10/1981 was the odd part. And basing on that, so obtained no objection from Tahsildar, suppressing this matter. Why?
You have to
And
verify.
thereafter,
You have to verify it. Nothing.
That we have no access. I did not disclose in the income tax also. But there are three transactions, right from, and there are again one more time in 2005. Take the property off the very. And 2005 mortgage by the. Thereafter, conclusion of. Purchase.
Third.
So that way we.
You should
Yeah.
you should have checked the title. You have not done.
1981 is concerned, as of there was no impediment to sell the property because 50 impose was it to 51 of land.
That order was quashed, mister. That order was quashed.
Fact,
Yes.
in the year 1985.
85. Then the second order was in the year 2002. Then within 15 years, how you could purchase?
But there is no imposition of such condition because we had no knowledge of it. We had no knowledge of it. Because we are the.
You have- It was for you to check. You cannot say that you had no knowledge. When you say that in the year 1981 order was tribunal had granted the order, it was for you to verify it.
That is the case.
You are not then the-
And we were carried away by the notification given by the Tahsildar in the year 2005. The Tahsildar could have said that there is a pendency of the matter, he didn't say anything about it. There of a question order was filed in the year 2005. That is on the lot by to believe that the property is free from all income, but it's such a low. Purchase property. Again, they told you to some other property. And thereafter we purchased and society purchased the land. And you have farmed it there. And you relinquished the floor of the local authority. And we don't know where this property comes in the 72 acres. But one layout made. But that is not the thought for but so far as money. We can't take to the tariff. I'm sure. No problem. Very far.
Who has paid for? Who has paid?
That is my tenant.
Your vendor.
The vendor. By regulation or whatever. They had interest in the agreement using that. Not only and then another crowd, serious. They're also sharing of. Okay. What are we going to tell? What you want to take of agriculture and cultivation.
Layout already developed. Layout is already developed. No. Whether he has developed it and sites have been allotted.
in the school. He was defeated and he admits that in 2002 he has verified the document and he had to know of the order of the serial number 12. He says immediately he purchases 2002 he had the knowledge.
During the pendency of this writ petition, was there any interim order? Of writ petition? Why the, there any interim order in that? Did you allow them to develop?
He had no knowledge.
No, purchase during the pendency. 2003 is the writ petition. So they have formed a layout in that. Layout is formed. Say that they don't know their property. In the property is being developed, they should have got it. Then you were not in possession of the property. If you are not, if you do not even know that your property is being developed by somebody else, then how can you say that you are in possession of the property?
Because of the land contract, disposal of the equity that is in the year 2000, data number 50. 2011, the was allowed to the order of land number. The school procedure that the telecom employees they don't keep the suit. Item number 17. The appeal was filed by the appellant hearing. That appeal will be received at item number 20. 51.
It's all subsequent to purchase. Year 2006, they have purchased. You are spending. Yes, at least if you would have brought to the notice of this court, the property is being developed, or it would have informed them that there is a petition. They have developed it and allotted to various people now.
That is a school. In that, it may, the knowledge of the land, of the year, therefore, his condition of knowledge.
If he has already developed and he has allotted the sites to various members.
They to know of the order of the land. And then it is a. Therefore, submission that he had no knowledge. On the face of it. Kindly go to 147. 147 is the order of the land tribunal. The 2002. Kindly go to the. Because we can use so. Take it from. It is 70. It's in Canada. 6.
Now this order is against you. Now his rights also you may have to consider. Not in picture. You are the affected party now.
They are present with the other documents.
It is your case. You have developed the entire land and you have also executed child deeds in favor of your members.
I propose.
Your client is willing.
That may not have the market.
That we don't know. That we don't know. You grant you time. You also were silent. So when they were developing the property, you did not either bring to the notice of this court or you did not bring to their notice that there is a matter pending before the tribunal or before this court. It was for you to bring so that they probably they would have got implemented in the repetition. We do not know. As on this date, according to you also don't dispute that the property is developed. It is developed. Therefore, and if they have allotted sites,
explore the possibility of amicable. How much time? Yes, sir.
both of you should be reasonable. Only they.
And the society will have to bear all the.
If you succeed again, getting possession of this property is also very difficult if it is already allowed. Yes. Now you have got an opportunity to put an end to the litigation, right?
Yes.
You can sit with them and you can find out why that they have sold, and accordingly you can also negotiate.
Change by 2 weeks.
Adjournment on the yes. On the next date. On the next date, we are not adjourning this matter.
Current counsel for the parties joint decree for adjournment them to ensure to explore the possibility of an amicable settlement. Needless to state that the appellant shall extend or reasonable shall extend an offer to the respondent can be acted upon. Ah,
You have not carried out complicated sanitation as per the order before. In respect of all the 60 overheads, I have some information given with me.
that what is about the status of their plantation business?
We submit
So we Mr. You are a very free officer. No, we want to know whether these orders are only on paper or something is there. Like 300 trees. We don't know how many old they are, years old. They will be cut and some this thing plantations, some people will cut it. It will be washed away in the rain. Who will do it? So we want to see that what happened to the previous plantation. And who will tell us whether, I mean, it is absolutely imperative to cut it and there is no other way out. This is all serious issue. Rampant felling of trees. Huh? No, but you will give us the report with regard to your compulsory afforestation. Wanted, not you will say, yeah, we have done it. Okay. Who will decide? Which order? Who appears for tree officer? Then Mr. Mish, yes. You have to be independent and impartial, right? Ah. No, you have to see, I mean, what? Sapling, no, saplings. So we would have directed an advocate, won't know. That's why we are asking you. Who will, they say that they have complied with all the directions. They have they must have planted 10 trees for 1 tree, like that. No. Well, what happened to those trees? We want to know whether, I mean, it's there or not there, something like saying here. So all right. So that's what. No, that's what. No, all right, all right. 47 out of 47,000. 13,000.
What are the reports are?
Which committee, Mr. Ah, that's what. Mr. He says I don't have any power to do anything. Hey, Mr. Ramesh, you can't. No, 'No. We need to get a report from an independent person. Who is that? You tell us.
No,
Ah,
with regard to,
from-
with
see,
regard to the state, we want the report with regard to the status of the saplings.
saplings planted, whether they are surviving, what happened, translocated trees, what happened to them? Who will?
September.
Year to come. 18 September. Hey. Where is that? Ah, no, who has filed? They means. Take. No, who is Mr. Mahindra? We are not getting answer to, answer to simple questions. Who is the first of all? Just please tell us who is the competent authority to tell us about state of compensatory and saplings, whatever and what translocation of trees, whether they are the authority. Some, he says I don't have power.
reports are, we submit reports to party report to them. For the federal rate and not the
So you said that powers have been given to high commit, what high committee, which committee? But you are required, you are a tree officer, right? What do you do? Nothing. No, if you are a tree officer, you are required to ensure that the trees are safe and they grow and they are planted. This is what tell us. No, answer. We want a report or your affidavit that this compensatory afforestation has been done. These trees which have been saplings which have been planted have survived and now they are growing and all this. This is really
That you obtain from them.
uh,
say. That show, we show it there, right, on the report.
but this the officer has not responded to this, right? This is their version of this. So let him respond first. Then we will look into this. Ramesh, let him examine. Well, no, but you represent the officer, right? Three officer. And who is the other one?
From the forest department.
The three officer is. Huh? Ah. No, but this is on the basis of information published by him, or you have inspected and you yourself have seen your this. No, but there are other areas also where BPMP has to do. That's why. That's why uh, let him. We don't want to hurry up with felling of trees, Mister. Seriously, we thought once we granted permission, but this is an unending process, right? Everywhere, like casually 300 trees, 400. These are you shade. These are old trees. New sapling can never substitute them. Forget about the case. Forget about that you want permission to take. Forget about it. But as a Bangalorean, you should know that those 300 trees, these new saplings can never be a substitute for them. They have been there for years together. We don't know how long. And we cut it and put a sapling which is washed away in the evening, today's evening rain. Nobody knows. Ah. You know, that is all theory on paper. Nobody knows. Nobody knows that sapling has washed away in yesterday's rain or not. This all paper, you understand, all committee, expert committee, this thing, they will give permission, it's all paper, on paper. What is the ground on the existing situation on the ground, that nobody knows. That's
So that's why we are calling up for a report. We'll find out.
right.
We'll find out who is correct or find out. Yes.
No. No. See, your stand is you have done everything and you be granted permission to fell trees. They are disputing it. We have to decide. That's why we are calling for a report from Mr. Ramesh and Mr. Yes, and Mr. He says he has submitted.
He has submitted on the basis of the report given by.
Sir, we don't think your officers must have taken the trouble to visit this spot. Whatever air condition he has, Mr. Sabras have given, he said yes, posted everything planted, done, site.
Not.
No, let him file photographs to show. We want to see these saplings. We will be easily granting permission. Contrary to our conscience, we won't do. File photographs, file that we want to know when you planted, what happened to the tree. It must be now. If you had planted sometime in April 2022, it should survive now. It's almost now 4 months. So we are granting you time. Tell us how much time, Mr. Mahindra and Mr. Ramesh. How much time will you file the report after inspection? But then he has visited when? When he has visited the sites, where he has visited? No, where he has visited and when he has visited and where he has said so that I inspected the sites and then I have found that all trees are in order and everything. But again, this is what, so right, have according to you, you have complied, but that's not the whole of it, right? Mr. Ramesh has to comply. You have complied, right? But we will put some inconvenient questions to your officer also. Tell him that this sort of thing he doesn't disclose when he is inspected. He says, but he's maintaining as of now that complied. See, now come to page 5. What is it?
Sabra says that everything is fine.
Huh? Huh? One seven completely right. More than 50% have tried. They have not survived.
75%.
75.
More than 70.
What?
Is transported. Out of 205, 172.
Out of 205, 172 have tried.
16 have partially died. Partially died. Only out of 205.
And what
17,
about the saplings?
Para 3 also, but has not completely carried out compensatory efforts today. Saying you have done everything.
See, this report is against you, Mr. Sab. Oh, see, line here, that. Okay. They said that what they have said is that you have not undertaken compensatory of forestation. In jurisdiction, no, that's what they say. We don't know. Para 5, page 5, they have said. Okay. Please mark the page. Yes, please. No, Mr. Ramesh, but you should act really like an officer of the court. Don't this thing that sitting in his office, he will prepare a report. These officers will come, will take him out for a dinner, and he will prepare sign. They will prepare a report, he will sign. Eventually, we will not spare anybody. Don't, I mean, that's why you please act as an officer. Convey to your officer all the sensitivity and the seriousness which the matter requires. Don't. See that IA 10. The Senior Counsel for Bangalore Metro Rail Corporation has invited the attention of this court to IA 10 of 2022 and has sought permission of this court to cut how many trees? 360, 300, 382 trees and to translocate 29 trees. The Red Council for the petitioner submits that the KMRCL has not complied with the earlier directions compensatory afforestation. It further submitted that that the status with regard to the tree saplings planted by PRM TACL is not on record. Full stop. And the Red Senior Counsel for BRMCL has submitted that reforestation and in terms of direction by this court has been undertaken. Full stop. Contradictory stand by the petitioner and respondents and to resolve the issue, comma, we deem it appropriate to we deem it expedient to direct T3 of BBMP and BBMP and Deputy Conservator of Forest Bangalore Urban inspect the sites and to submit report. No, was submitted a report. No. Direct the tree officer BBMP to inspect the site and within his jurisdiction and to submit a report with regard to status of compensatory afforestation as well as status of the tree saplings plant. And as located trees. Right. One for Mr. Sabrat also respond. What is this memo of compliance filed on behalf of Conservator of Forest on or before next date of hearing? Where do you want it? Cutting the tree, you can't do anything else, right? Do it. Hey, Mr. Do it.
There is
Yeah.
the government has submitted a report.
See, they are saying that you have not done. And maybe perhaps government is right this time. We don't know, subject to what you say. So weeks time, right? Please. Also, do it. Why? He is a tree officer, right? That will give him the sense of urgency and this thing. The seriousness. 12 September, right? 12 September. This on. In advance, Mr. Don't get fly on that day, otherwise it will be agenda again. 12 September. Right?
ಮಾ ಕೋರ್ಟ್ ಕೇಸ್ನ ಹಿಯರಿಂಗ್ ಮಾಡ್ತಾರೆ ಲೈವ್ ಆಗಿ ತೋರಿಸ್ತಾರೆ ನೋಡಿಲ್ಲ ಪೋಣಿ
Praying for it. We would have. Why, Mr. No, objection means we will reject it, so there will be no objection, right? IA we will, no, IA we will reject, so there will be no objection. So you argue. So then why don't you comply? See, Mr. 1-8, same thing. Senior be argued by senior counsel. Huh? No. He is right in saying that this is the second and 2 occasions you have sought adjournment on the same ground. Senior, what does senior? Senior doesn't mean God, right? That is not gettable easily. Huh? No. Senior means doesn't mean God, right? Correct. Correct. Senior, what does it mean according to you? Senior means no. Senior counsel means what? What means what? Who, the one who is not available. Or in senior counsel means a person in whose name perpetually you have got the license to seek adjournment till this court exists, and who will never appear before this court. Mr. The order sheet says that you have sought adjournment. No. What is you are Mr. Gururaj Deshpande? Oh. So where is you know Mr. who is Mr. Gururaj K. Deshpande? Huh? Gururaj Deshpande appeared and submitted that matter has to be argued by senior advocate who is senior counsel who is not available. You are not the person, right? You are not the senior counsel. Then we adjourned it. Thereafter, Mr. C.S.M. Chandrasekhar, he is senior counsel, he appeared and he sought time for adjournment. No. He prayed senior counsel for petitioner prays for adjournment. No, we don't know what is the reason. The reason is third time you are seeking an adjournment. And so the result is we will not allow the interim order to be extended and 4 weeks. You want. No. No, we will not adjourn. We will not extend it. You take adjournment. What you? So you are free to take adjournment. No. What person will be? We have read out this thing, right? 2 order sheets. Correct? No, we don't say incorrect things. We only say from record. Correct means don't give us that certificate we are correct. We have told you. Why? Today is not a date. Huh?
You wanted time to rectify the office objection.
No,
What is
we-
the office objection? When was the application filed? 11th.
Okay. Next time we will say that if you seek an adjournment, interim order shall stand vacated. Right? Huh? Tell us a date. How there is no problem. Mark the presence. Learned counsel for the petitioner again prays for adjournment on the ground that senior counsel is not available. We have perused the order sheets. Adjournment was sought on similar grounds. On the same ground on 1/8/2022. Thereafter, 11/8/2022, the senior counsel in whose name the adjournment is being sought repeatedly himself appeared and sought adjournment. The prayer for adjournment is opposed by learned counsel for respondent. However, by way of intelligence, who is opposing, right? Don't look at it. We are not writing. Are you opposing or not? That twice. Otherwise, we would not have got it. He is opposing, no, right? Learned counsel for respondent has opposed the prayer. However, by way of indulgence, let the petition be listed on when 14 September, the appeal be listed on 14 September 2022. It is made clear that in case the appeal is not argued, the interim order shall stand vacated.
Government advocate, Mohan S.
Yes. Huh? Why? Why? What will happen to cases which are scheduled? I mean, every case next week, then why praise for adjournment just after 4 weeks? Praise for adjournment, enable to prepare the case and argue the same just after 4 weeks. Why next week, madam? Next week there will be some other cases, no fresh filing during this week it will come up. Why this case? 4 weeks. You are ready, then why are you seeking adjournment? Whether you are ready or you are not. If you are ready, please argue. Don't say that I am ready, thereby giving an impression that we are adjourning. We are not adjourning. Say so. You are simultaneously saying I am ready. So we will hear it if you are ready. Please argue. Say, madam, that I am ready. We don't want to adjourn it. We are ready to hear it. We have made notes. We are ready with the case. Even if you don't argue, we can pass an order right away. We know what is what. Don't say they say seek an adjournment and they say I am ready. What is this? Either you are ready or you are not ready. That also you don't know. Facts of the case you don't know. That's fine. But that also you don't know whether you are ready or not. So argue. Huh? Huh? Notice has to be served. Has been issued. Huh? You will have to argue on admission, not think this. Then every case, why should we hear then everybody? All case admission. The life of a judges are not so simple. That cases admission matters 23 to what should notice. And you will have to tell us why notice should be issued. You are saying in arm land, therefore notice should be issued. Not like that. Then please argue. You have to make out a case for admission, right? Issue notice. And it will be subject to result, right? Whatever happens. Yes. Next. Notice on admission, I need to work 20. What 8 office objection 7 times. Your client is not interested. Huh? He is not interested in prosecuting. That's why. Notice has been ordered by him. And interim order also granted. Regarding office objection. Even before issue of notice. We will see what is the order on 30th 9/21. 3 weeks time. Comply with office obligations, failing which appropriate order shall be passed. Not that you don't know or nothing. The time has been granted to you. 30th September. 2021. 30th September 2021. 1 year ago, 3 weeks time granted to comply with office objections, and you are today you are telling us that you don't know what are the office. Don't you think that instead of arguing it on what happened, history, you should comply? Yes. So we will say that week's time failing which appeal shall stand dismissed. Week time is finally granted to Larit to Mr. Bright is present. Mr. Venkatesh is granted a week's time to enable him to comply with office objections, failing which appeal shall stand dismissed without. Yes. Huh? You be here, right? Huh? You, huh? AG was appeal. You are respond number 5, right? Why do you stand in the place of appellant, giving us an impression that Yes, who appears for the appellant? Passport. No, who? Who appeared?
And serial number 3 was going on. He has appeared.
Ah.
Same person.
Oh. Here at yes.
He was browsing. Yes.
Millets, I am here, Millets, in item number 35.
Same matter. Start for adjournment. Yes. Yes.
How much it did? What?
Millets, I sincerely apologize for my grave mistake. Millets, first, please let me apologize,
No,
Millets.
no, we are not interested. What do you want?
Millets, I need short
You
adjournment.
are appearing for the appellant, right? You were given
Yes.
time.
Yes, Millets.
So what happened? You wanted to
Millets,
file some objection.
No, Millets, I just Millets, my senior, Miss Neela Gokle is here.
Yes, madam.
Sorry, there is some my video, so but I was a little unwell because I'm not able to tell the objections. I'm just any 4 or 5 days time to file the objections. I'm extremely sorry that I was not able to get in touch with the video thing. Excuse me,
We want your assistant to find out how much time they have said everything except time. How much time they want except that.
How much time do you want, madam?
About a week's, my lord, 1 week's time.
Simple, right? Yes, this council, Mr. Singh has made it so complicated, right? Simple thing. Ask presence learned council for adjournment. 23rd.
Very well.
26th, madam. 26th September.
Yes, my lord.
Praise for it.
Yes, my lord. It's fine with me.
You are praying for adjournment.
I'm grateful.
What? Why do you
Yes,
want
my
an
lord.
adjournment?
Yes, my lord.
Praise for adjournment
my lord,
on the
because
ground
I
that
am
she is not well. All right, she's unwell. List on 23rd, 6 September 2020.
Mills, I also Mills apology on behalf of Junior Mills. He was a little too.
Madam,
I am so sorry, Mills. I'm just please accept.
No, if he's your
Well,
colleague, we want to tell you that please advise him. We were taking up item number 3, and councils were making a submission, and he intervened and said that I want time. That's what we
I'm
told
so
him.
sorry,
This
Mills.
is not done.
I'm extremely sorry.
Once a matter
Absolutely,
is going on,
Mills.
item number 3 was going on, and he is telling us that in item number 35, I want a week's time. So we were hearing submissions of other councils.
Yes, Mills. I appreciate Mills. I bow down, Mills. I'm so sorry on his behalf.
Know the etiquettes if they seek the liberty to directly
Absolutely.
address to the High Court, then they should know what to do.
Absolutely. Absolutely, Mills. I just bow down and I'm so sorry on his behalf, Mills.
No, not.
Thank you,
not
Mills.
sorry.
I'm grateful, Mills.
Realize. Yes. Mr. Kasturi is waiting for a long time since 10:30. We just like. Yes. Mr. Kasturi, which case you are appearing? Yet to be called 36, we have reached.
Mr. Subbarao has moved your lordships. Serial number 65.
That will take some time, right? We are at 35.
Yeah, of course. I argued for two times before your lordships.
No, we don't know.
Further hearing.
No, you are online since 10:30, so we thought of, asking you. We could resist the temptation that which case you are appearing.
I am happy to hear your lordships.
All right. Oh, it's a pleasure to see you also. Same way. I mean, it's this thing, same you on
Adu,
mutual.
your lordships
But
can kindly take it up on the
Srikanth is appearing, yes. You know what I mean?
16th or 17th.
Not like this.
I will
Just now
mention
told her.
at 2:30. I will mention, my lord.
Ah.
I will mention at 2:30, my lords.
Yes. Yes. Ah, heard to be heard. Purity dispute. Ah, so this has to be heard, right? We'll admit it. It is admitted for hearing based on 10th of October for hearing. That doesn't matter. So we are hearing it finally. Typing mistake. Yeah, typing mistakes. I checked it. In my notes, it's correct. The stenographer has got it wrong, and that doesn't affect the merits of the case because the interim order will merge into the final order which will be passed. Huh? No, it's being heard finally. No, we have recorded facts for our convenience. Nothing. I mean, there is no interim order, right? What we have. No. We have. Or you file an application. Correction. According to us, it has no bearing. I checked because you were this thing. I checked my notes. Notes the dates are correct. The stenographer has done it wrong, and it will. Why has that? You are at liberty to file an application seeking modification, recall, whatever. There's nothing. There is no order for our facility. We have recorded facts. There are. Rightly point out those dates are wrong, but since we are hearing the petition finally, it will have no bearing on merits. But you find learned senior counsel for respondent is granted the liberty. Which order? Uh, learned senior counsel for respondent number 3 has pointed out that certain typographical errors have kept in has certain errors have kept the order dated 1/8/2022. The appeal has already been admitted for hearing. The same shall have checked. The same shall be heard finally. The facts, the order dated 1/8. We have perused the order dated 1/8/2022. No interim order has been passed. The facts have been referred to. In case of any, uh, in case the respondent number 3 is agreed, he is at liberty to seek review, stroke recall, stroke modification. See, you write by an order dated 1/8/2022, this court has not adjudicated any of the rights of the parties. However, case respondent number 3 is agreed. it is open for him to file an application seeking review, recall, stroke modification of the said order. Let appeal is then admitted for hearing, list the same for final hearing on whatever.
Mahesh Chaudhary.
Huh. Huh. You tell a short issue and then we end up passing long orders. My, my brother has seen in the chamber how short the issue was the other one. Lighter one, nothing, lighter one. It was really need a short issue, but nonetheless we had to write this. What is it? No, very few lawyers we can take liberty. So that's why we, because like you saw Mr. Verma Kumar so serious, and nothing, we have not done anything. But the people don't seem to enjoy humor also. So that's why you are just like that. Nothing. Yes, if you, what is it? Uh, sure. Uh, Completely. Hearing. But we'll then dismiss it for default. Otherwise, if we pass an order on merits, he will, you know what, they will file an application for it. For first round, order has been passed in violation of principles of natural justice. Second time, oh, then this time we should maybe you remind us for restoration. We will impose cost. Or we can pass over.
What happened
Password.
after the
That order has been given in effect. He will file an application for what? So the only thing is we are this thing, thinking whether he files an application for recall, what will be that without hearing an opportunity of hearing. So, what happened? Following the one, two, three. Finally, but where is this argument that he has no locus and nothing? Then that's why by seek review, that's your remedy. We can't entertain an appeal on a ground which was not raised before the subject. By review. Mr. P.S. Sachin, learned counsel for the applicant. After arguing the matter to some extent, learned counsel for the applicant of this court to withdraw the appeal with the liberty to seek review of the order dated 24 June 2019, passed in WP number 56182. Accordingly, the appeal liberty as paid. Yes.
But I appear for respondent number 1 in 40.6, my lord, that is writ appeal number 92 of 2022, madam.
It has been admitted. No. of June. Where is 10th of June? Ah, yes, yes. No, notice has been issued, sir. Notice has been issued. Issue notice to remaining respondents. They have been served, everybody. Will admit it. The only this thing is, Mr. As we get it, your contention is the managing director did not accept the recommendation, but he referred the same to that subcommittee. That's the only point, right? What is to be heard? Let them be
There's
heard.
also one more issue, my lord. There is also one more issue,
Oh,
my
one
lord.
more
May I
issue.
submit? Lord, may I submit, my lord? There's also one more issue. It was a specific contention, my lord, that the director had no, there was no amendment to the
Appeal is
RMP
admitted for
registration.
hearing.
Please.
Rehearing. What? Who will rehear? Why? No, everybody has been continuing. Where is it? Whosoever is not ready? No. Where is it? Whosoever is not relieved. Nothing like that. Whosoever is not
Petitioner.
there.
F clause F, petitioners who are as on the date continuing the work.
Everybody.
When you have continued the others, why don't you continue him also?
It is all, he is also similarly placed, right? And that restatement is dismissing the appeal. Where from have you learned this law, Mr.? That if an interim order is passed against the respondent, that means appeal is allowed, right? He will say that, oh, you are granting an interim order, so it is virtually allowing an appeal. Where from have you learned all this law? That supposing if we decide restatement that your appeal is dismissed, what? No, you said no. Virtually dismissing. Whatever it is, no. That if we say that you restated, that means dismissal of your appeal. Where do you say? Where do you get it? It won't be dismissed, right? Why should, why should you say like this? That if we supposing if we say that your appeal will be dismissed, can we?
The others are continuing, how it will?
No, others are continuing. So what happens? So your appeal is dismissed if others are continuing. 4 appeals should be dismissed according to this. South place. You said you require hearing. It requires hearing. You told that it has been last rated and it is not edited. File an application. Stay. seeking stay.
Why he has filed an application for
Every point, whether he has this thing. It says that he has disagreed, that's why it has been referred to something. Let it be. Hearing sometime and file an application for urgent hearing. Huh? Oh. You going to retire? 3.5, third on number of option for that it's like the all other employees like respondent continuing in service. However, he alone is not being reinstated on the ground that on the date of passing of the order of learned single judge, the respondent number one was released. It is further submitted that respondent number one is annulled on 31st of October 2022. Paragraph. Pending adjudication of the controversy involved in the appeals, it is directed that the appellant shall reinstate his it is to state that reinstatement of one shall be subject to result of this appeal according to 2 of 2022 and 22 and 2 of 2 are disclosed.
Srinivas Ken.
On number 3, all right, office is directed to reflect the name of Venkatesh Bhakti as on number 3.
The exam doesn't work.
41, I'm appearing for respondent. Just no, my lord, by email I.
Reinstating is to just a fact of based record, but I didn't notice it.
You are devotees and therefore you are local.
Right.
Matter is to be heard, my lord. A synopsis have already been sent. Any matter could be heard in the meanwhile. Just now I received an affidavit sent through my email. I got it print out now. Some order they are alleging that somebody have violated.
No, not reinstating. Tahsildar has passed an order reinstating your clients.
Yes, my lord. Now that order is there, and
what he has pointed out. He's saying something else, non-compliance, something else.
Issues like this. There are 2 objects now. 3 objects who are not respondents. 3 of them, 2, 3, and 4. No, they stopped performing puja admittedly on 7th October 2000. Of the temple. Proceeding was by me at the head of the managing proceeding resulted in an order passed by the deputy commissioner. Quoting that what it was wrong. Challenge in appeal by me. During the pendency of the appeal was the stay order in operation. They were not functional. The appeal was dismissed by the writ petition. The writ petition not the order was there. They were not functional. The ground. The devotees.
ರಮೇಶ್ಗೆ ಫೋನ್ ಮಾಡಿ 2 ಪುಸ್ತಕ ಕೇಳಿದ್ದೀನಿ ಮನೆಯಿಂದ ಕಳಿಸ್ತೀನಿ ಯಾರು ತಗೊಂಡ್ಬರ್ತಾ ಇದ್ದಾರೆ
Take note. It is 1022. Page number 16. By me. After the January. Page number 22. To Sri Ramachar. He is not responding. Regarding appointment of Archar, Alambagiri Venkatramana Swami Temple. Yes. Dated 5/11/97. So appointed to the Sri Ramachar and V. Sudarshan Acharya, Alambagiri. Petition cases after the death of the father. So the order of the deputy commissioner. In 2 years from the date of the order to the temple committee or the Muzrai department. You know, say, so direct immediately to the certificate of passing the Vaikana Sadhama Parvara exam. Come to the notice of the temple committee that from the past 1 week you are not performing the daily pujas daily. You know, the same we should consider committee disconduct. It is not good. So it's possible to what we can do. Therefore, the same. Please go to page number 70. First order. This is the inquiry of and it is confirmed front of this by not performing puja, not down the started it. Continuing Ramachan. Immediate effect to the following points. The losses will get the appeal order at page number 86, English translation. Page 101. The basic question of locus. The appellate authority held what should I have locus? Slide page 101. Commissioner filed appeal number 2. Question the said order. The contention of the respondents that they have no interest in filing it. They have donated more than 30 lakhs to the development of the temple. And excavation, gearbox, Tara, and maintenance from Japan. Over the 15 being devoted to them. Interest Also, first respondent is rather development. Second respondent is they have no interest in it. Fine. State law. I mean, so it can see the derivation. 105. Steps to find. It is immediate to duty and start continuing the service, bring down the honor, prestige, and character of the citizens. And appointed on building their cases that they have just. And they will prove that they will qualify this exam. Appointment letter. That has not been done. On the delegations, considering locking up the Devasthana, also as of serious, so that increments are the two types of punishment cannot be considered in the life. One is the accepted punishment imposed to the Deputy Commissioner if they are not questioned regarding audit report. One thing day before yesterday, when this order of made subsidies got during the pendency of the appeal, the Lordship kindly recalled the order. Every time I made a request, he said, "Oh no, we will see that nothing is done, nothing is done." I have naturally not stating what happened on all those days, and the officer, son Lord, he had sent a deputy to be present in court. He saw what transpired before the court. The Tahsildar is about to retire. One day before Lord, he starts to take an order. Reinstating this. From 2001 till now, 21 years. It's just not long.
Yes, Mr. Rajput.
Lord, very just no, my lord, I they send me an affidavit. Making certain things to me, my lord, just I got it by printout, my lord. I don't know A to ABCD of that contents of that affidavit. Number one. Number two, my lord, the matter has to be heard. He has argued.
He has been, see, the learned single judge and he has no locus, he has pointed out.
My lord, it is true because your lordship may kindly see, my lord, an inquiry was initiated by the deputy commissioner so far as misconduct committed by me is concerned. In that inquiry, my lord, a punishment was imposed and the punishment was challenged by the other group, that's the appellant before this honorable court, before the endowment commissioner. The endowment commissioner confirmed that order and said that that's a cumulative effect, there is a withholding of salary is there. Therefore, it is a major penalty. He closed the appeal. They have filed a writ petition. When the writ petition was filed, they are neither the members of the committee nor having any rights so far as the temple is concerned. Ultimately, two reasons are assigned by the learned single judge. Your lordship may kindly see the order of the learned single judge for a moment. At page 36, paragraph 3. Learned senior counsel vehemently contended that having regard to the seriousness of the alleged allegation leveled against the contesting respondent, deputy commissioner and commissioner should have imposed a major penalty. Since the temples are locked abruptly on many occasions, it was brought to the notice of Tahsildar and revenue officials are also not so serious about the allegation. In fact, one day, temple was opened by break open the lock, etc. No doubt alleged allegation charges leveled against the contesting respondents are serious in nature. At the same time, one cannot ignore disciplinary proceedings initiated and completion by disciplinary authority and appellate authority. It is the discretionary power vested with the disciplinary authority, appellate authority to examine both the disciplinary proceedings, suo motu action. Petitioner are third parties to the disciplinary proceedings. Therefore, prima facie, they have no locus to question validity of the action, import penalty by the deputy commissioner, confirmed by the commissioner. Accordingly, petitioner have not made out a case, hence the writ petition stand dismissed. My lord, punishment imposed is, your lordship may kindly see the order of the deputy commissioner, my lord, your lordship will get. May kindly go to page 75 minutes. Operative portion of the order passed by the deputy commissioner. My lord, the number one, unauthorized absence from 7/10/2001 to 22/10/2001 will be considered as unauthorized absence number one. Fine of rupees 2,000 each has been imposed on the above two checks. Sum of rupees 200 has been cumulatively cut, and the pay of the above three checks. A cumulative effect, my lord, 200 rupees salary have been withheld. This is a major penalty according to law. It is a cumulative effect, not only once, my lord. This order was confirmed by the appellate authority, Annexure B, that is the order of the endowment commissioner. My submission to your lordship is, I filed a synopsis and also the judgment of the honorable court, a list of authorities I passed on 7th, my lord, your lordships may kindly see me. The first judgment on the point is 2022. SEC online 284, the Supreme Court judgment I cited. Paragraph 9 may kindly be seen. May I read it, my lord? Para 9 of the judgment rendered in the matter of Union of India versus Manogavina Samasatari. Para 9, this is reported in 2022 SEC online 284. May I read it, my lord?
Yes.
Impugned judgment by the division bench is difficult to sustain as it equates appellant power under section 52 of the CISF rule 2001. Power of judicial review exercised by constitutional courts. Rule 52 of the CISF rule 2001. Employers of the inadequate pass consequential order confirming, enhancing, reducing, setting aside the penalty. In the present case, procedure required issue of show cause notice. Competence of the principles of natural justice is met. Quantum of punishment is within the discretionary domain and the sole power of the decision-making authority. Once the charge of misconduct stands proved, such a discretionary power is exposed for judicial interference, exercised in a manner which is grossly disproportionate to the judicial disproportion making authority once a charge disproportionate fault as the Constitutional Court, while exercising the power of judicial review, do not assume the role of the appellate authority. Writ jurisdiction is circumscribed by limits of correcting the errors of law, procedural error leading to the manifest injustice or violation of principles of natural justice. The decision are also disturbed when it is found to be ailing and perversity. On the question of quantum of punishment, court exercise the power of judicial review can examine whether authority has been reasonable employer, has taken into consideration measure, magnitude and degree of the misconduct, all other relevant circumstances, excluded relevant matters. In the context of quantum of punishment, these aspects or merit of quantum, etc. This is the law, my lord, holding the fit. This is, my lord, earlier judgments are also I produced. My lord, 2029 SCC page 471. Next judgment, my lord, paragraph 36 and 38. Praveen Kumar versus Union of India's case.
That is all right.
Then, my lord, the another judgment, there are identical. Consistently, the Supreme Court have taken the view. My lord, now, along with the writ petition, they made an application to produce a document to show that we have the locus. Could your lordship may kindly have that application for a moment? They have produced a document number 1, where, my lord, there was an order appointing a committee which is headed by the present appellant. This committee is, my lord, constituted under section 40B of the Act. Section 40B of the Endowment Act, a committee is constituted only to manage the renovation of a temple. It is nothing to do with the administration of the temple. If a committee wanted to invest on its own, may kindly see rule 40B, maybe. Endowment Act. 40B, a committee could be appointed by the government to renovate the temple or reconstruct the temple or improve the temple. That committee is nothing to do with the administration. Even another committee could be there. Ultimately, my lord, under the provisions of the Endowment Act, more particularly, my lord, by virtue of the provisions under Rule 17 of the Karnataka Hindu Religious and Charitable Institution Act, read with Rule 24(2) and 50 of the Act, an inquiry could be, a domestic inquiry could be conducted by the Deputy Commissioner. Deputy Commissioner's order imposing penalty would always be a scrutiny before the appellate authority, Endowment Commissioner. Both have taken the view punishment imposed is appropriate so far as the gravity of the misconduct is concerned. They have pressed the matter before the learned single judge. Learned single judge, it is only a committee, nothing to do with the administration. Any of some punishments is there, whether it is correct or not cannot be gone into at the instance of the appellant. Therefore, my lord, the writ appeal they have filed. My submission is, in view of these facts and in view of a settled legal position, my lord, a punishment is imposed. A 200 rupees is withheld from my salary cumulatively throughout my service. It is not a, they are all checks. They are paying, my lord, 2,000, 3,000 rupees salary. They don't have the pay scale or increment, additional increment, HRC, like that. No such other contingencies are not there. Out of it, 200 is withholding cumulatively throughout my service. Now, my lord, the order was passed by the learned single judge. Your lordship may kindly see the date of the order for a moment. 17th August 2021. We are almost all 1 year completed. In spite of 1 year, this order is not implemented because of the appellant before your lordships now. Anyhow, my lord, when the matter came up before your lordships last occasion, matter could be heard, your lordships opine. Therefore, synopsis and very other things have been filed. In view of this, my lord, my submission would be, may kindly dismiss the appeal, my lord, as they have no locus, much less there would not be any merit also. It is covered by the judgment which I have cited so far as the issue in controversy is concerned.
But the question is the appointment letter says if you are qualified within 2 years. CH-2 says that. In their first appointment order also it says that. First appointment order is also on record. I filed it on 58 months. It's complete. So this order. After finding that what they did was dereliction, from 2001 onwards, they never performed puja. Now, Lord, to reinstate them back when there is no material to show that they are qualified in this exam. But where a judge had gone into the links of the case and had heard me on this issue, probably will not have taken a decision. Personal and no qualification. He to continue like this by virtue of an order. In a medial penalty of 100 rupees. So far as my locus is concerned, not there is a finding in my favor. I go.
Eligibility is not the subject matter, my lord. Misconduct is only the subject matter that was decided. That was not an issue before any authorities, including the writ petition as well as before your lordships. Only charge of misconduct is there. Punishment was imposed. Question is whether it is correct or not is a question.
Same committee has continued not from time to time. The latest order, my lord, of 2020 also have produced, my lord, with the 28. There's an application filed by me for production of patient documents because it's after that proceeding is over. In that also, my lord, the same committee is appointed by the government. Therefore, my lord, to say that no locus stand and all. This is an exercise which has been done during the pendency of the proceeding. That I have not sought any prayer because I don't even have a copy of that order. This is what we learn on the affidavit stated. Tasildar on the verge of retirement has made this. Not the status quo ante which has prevailed all these years. Restored.
According to the Neelakanth for
How many cases earlier? How many? Two 226 cases.
Yes.
Next matter 43, my lord.
Huh.
I want some time, my lord. I'm not
Hey,
able.
Mr. Why are you not coming to court?
I am
You
coming, my
need
lord,
to coming.
today. No. Today I had a small injury to my leg. I went to the doctor. I'm not able to come. Last day I was there, my lord. I was very much present before your lordship also. 2 weeks, my lord, may kindly be interim order to be continued in that matter. I assure that I am coming next time, my lord, without fail.
Judgment on the ground. Just after 1 week, interim order. We pass an order. Consider your prayer.
ಜೇಮ್ಸ್ ಸುಬ್ರಾಯರ್ ಒಂದ್ಸತಿ ಊಟ ಮಾಡಲ್ವಾ?
ಏನಪ್ಪಾ ನಾನು ಮುದುಕ ಊಟ ಮಾಡಲೇಬೇಕಲ್ಲ.
ಮುದುಕನ? Your attitude and appearance shows that you are the youngest lawyer.
ಹೌದಾ?
ಮತ್ತೇನು?
You take me as your junior. ಏನು? ಕಸ್ತೂರಿ, what are you going to do?
ಸರ್ ನಿಮ್ದು ಮ್ಯೂಟ್ ಆಗಿದೆ. ನಿಮ್ದು ಮ್ಯೂಟ್ ಆಗಿದೆ.
ನಾವು ಹೇಳಿದ್ ಕೇಳಲ್ಲ ಅವನಿಗೆ. ಹಲೋ,
ಆಫೀಸರ್ ಮ್ಯೂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಇವಾಗ ಓಪನ್ ಆಗಿದೆ.
ಕಸ್ತೂರಿ,
ಸರ್,
what are you going to do?
ಮ್ಯೂಟ್ ಆಗಿದೆ. ಕೇಳ್ತಾನೆ.
ನೋಡ್ಲಿ, ಹಾಗಾದ್ರೆ ಬರೋಣ 2:30 ಅಷ್ಟೇ.
ಸರ್ ನೀವು ಮಾತಾಡೋದು ಕೇಳಲ್ಲ ನಮಗೆ, ಮ್ಯೂಟ್ ಆಗಿದೆ.
ನೋಡೋಣ 2:30. I oppose, my lord. ಅಂತಾರೆ. ಊರಿಗೆ ಹೋಗಿಲ್ವ ಸುಬ್ರಹ್ಮಣ್ಯ?
ಈಗ ಎಂತದಕ್ಕಪ್ಪ?
ಊರಿಗೆ ಹೋಗ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ.
ಅಲ್ಲ, ಅದು ಮೊನ್ನೆ 3 ದಿವಸ ಹೋಗಿದ್ದೆ.
ಹೌದಾ?
ಹ್ಮ್.
ಕಾರಲ್ಲ?
ಇಲ್ಲಪ್ಪ, ಐ ವೆಂಟ್ ಟು ಕೋಲಂ.
ಕೋಲಂ.
thing is, right, you don't want his house and you want Mr. Rajshekhar's client to purchase it. Well, this the reason is that this one. You are not a property agent. You are not a real estate agent. You are a bank, right? You are not a real estate. Some sort of this thing, Mr. Pursuing up to remedy against what poor man has done. He has taken loan from you. He has repaid it. So despite that, you will not be satisfied. If he would not have paid, we would have. But he has paid, got your money back. Despite that, you want to sell his property and you want that he should purchase it, right? This is it. So we will hear you, of course. It's all. It's not that we are prejudging the issue. We will hear. Don't worry. Property. We don't. Yes, yes. It affected. The order operates inter parties. It does not issue an order in rem that all auctions held by the bank are nullified. Nothing of that sort. Huh? But we don't think that this is relevant for the purposes of any legal issue that borrowers will have. What is your point? What route? What is the legal in permitting the order?
Less than 30 days, calculated from the date on which notice of the proclamation was fixed. Recovery officer, the time of sale shall be fixed by the recovery officer, and the days of sale shall be the village where the property is sold, situated on such adjoining prominent place of as recovery officer.
But no finding is recorded by the single judge.
Paragraph 5. Page number 70.
That is your submission.
Paragraph 5.
Where is the finding?
Is not made with full conviction and not willing to this court. This is the one down to.
Maybe, but there is no finding as such with regard to the interpretation of Rule 38(2)(g). But a single judge has not given a finding that even auction held in any other place other than the spot, that is a valid sale. There is no finding as such. Therefore, it will not affect any other sales which you have conducted.
Again, my lord. Initially, sale proclamation was issued on 18/2019, 15-day auction on 23/2019. That has been not took place. Again, on second auction was proclaimed on 25/4/2019. On 15-day auction on 27/5/2019. On that day, government approached bank on that day to adjust the auction here. But now that point of view is not proposed anything. Just try to keep up strongly. That
Yes, yes, we are hearing you.
Yes, 5 to 50% promise. Again, that option also not took place. Again, third proclamation
No, there is no dispute that it was first auction, not the third one. There is nothing like this. Nobody is saying that it was first auction, not the third one. Nobody is saying. No dispute. You said, first of all, you said that every sale, every other sale conducted by the bank shall be set aside. So my lord pointed out that there is no interpretation of Rule 38(2)(g), right? There's no finding is given with regard to interpretation of 38(2)(g).
RFI, only learned single judge just said that submission is not made in full conviction, that's all.
Not appealing to the court. This is not the ground for setting aside. Right? You have got your money back, right? We will record this whenever you have got your money or not? Huh? Not. So, but it has been deposited. Right? Yes. You will get it right. So what is it? What ground you are challenging the order?
I don't think this one. He has not raised anything. After issuance of sale confirmation order, he has to deposit sale confirmation order.
What? Yes. Oh. Okay. Please argue.
Within 30 days from the date of sale of an individual property, the fifty or any person introduced there is the same. May apply to the required secondary sale on ground. Yes, sir.
Rule 38. Sale can be set aside only on the ground of irregularity.
Taking steps to as the motion said. After identification before the inquiry officer. After last 30 days, we will inquiry officer. And then he said.
So this thing is why he has committed the offense of repaying the amount of loan he sent to jail. Borrower, right? This is the argument. Huh? What? Why he has committed the offense of paying back my money? I will sell his property to the appellant in other case, and he cannot even afford to repay the amount of loan. Not find any application for setting aside sale before recovery of.
30 days from the date of auction sale.
What amount this property was sold?
81 lakh.
81 lakh.
81 lakh. First 21 lakhs to the appellant bank.
We are surprised that despite the fact that you have got your money back, you are still agreeing. He can fight it out. He is a private individual. He is whatever right. But what do you have? We really don't know. What shows? Yes. Got their money back.
Even statistics. Repetition. Some report to deposit of 50% of the
Usually deposit level and like thereafter, deposit remaining. He has to file application for confirmation of the sale.
Hardship that you are by this order, by the order of the single judge, what is the hardship that is caused to you?
Okay, sir, please understand it's a discretionary jurisdiction. It is not necessary for us to interfere with the order because you want, right? It's a discretionary jurisdiction. Repeatedly, fourth time we are asking you, have you not got your money back? What is your grievance? If he argues, it is understandable because he will lose the property. But you have got your money back, right? What is your legal grievance? Except for saying that he should have filed and then done that. So you have got your this thing. Whatever due you had, he has paid the amount. Financial institutions now act as real estate agents. I mean, we have come across allegations in many cases. Maybe this is true. Who still want to act as real estate agent and want to sell despite his property, despite the fact that you have received the amount. Why should you have filed this appeal? We really don't know. There's no findings. There's no finding on this thing. This submission is equally misplaced that on the basis of this order, all sales conducted by the bank will be invalidated. We don't know where from you are getting this. There's no finding, my lord has pointed out. There's no finding with regard to 38(2)(g). He has said that since he has deposited the amount, attempt should be made to give this thing a chance to the borrower to save his property. Why are you after his property? That's what you are a bank, right? Huh? Or an agent dealing with real estate business. Huh? You are a bank. Huh? So you are concerned with, you are dealing with public money, you have lent the money, you want it back. And you have got it back. Got it back. It's not that he has not deposited. This thing is why he has deposited. He should deposit. We'll deal with your legal subject. Not necessary for us to interfere in every case because maybe he should file an application. No, he should file an application within 30 days for confirmation of sale. Before confirmation of sale. That sale can be set aside only on ground of irregularity. That's all is fine. But it's the jurisdiction under Article 226 of the Constitution of India is discretionary and equitable. And if the learned single judge is exercised his equitable jurisdiction and no prejudice is caused to you, you tell us why should we entertain your appeal and why we should cost. You tell us. Extraordinary jurisdiction, discretionary. Nobody can compel us to exercise it merely because you point of necessary for us. It is just an equitable order. A borrower has paid the amount to you along. Despite that, you want to sell his. Tells the story. The loan is 21 for 81 lakhs. And despite that, I mean, you are having got your amount, still you are filed. Bank, cooperative bank. No. You have the same, like what he argued. No, there's no finding on 38(2)(g). No finding. There's no finding. Many a time, like passing reference, sometimes you say no. A council argues but does not press that point. That's why learned single judge is recorded. There's no finding on interpretation of 38(2)(g). Jurisdiction is extraordinary discretionary. According to us, an equitable order has been passed by learned single judge in exercise of extraordinary jurisdiction. And nobody has a right, he has a constitution under Article 308 that cannot be taken away by the bank despite having recovered the amount. Oh, you have convinced the bank, you have brought them here. That we didn't know. Eventually, say that every action bank conducted by the bank will be set aside. That will be decided on its own. There is no finding. Hey, we don't know what is done. That is not relevant for this case. Right? Yes, that petition there. No finding. Oh, you have been granted stay. See, Rashikar has been granted. That's why he is not. He's saying that if you don't have a case, he also doesn't have a case. That's why he is not opposing. Huh? So you want that not even file a writ petition. This is not fair. Access to justice is a fundamental right. But fundamental features of the Constitution. How can we prevent persons like Mr. Rajshekhar to not to file a petition? Lord has pointed out, right? There is no finding on you contest those petitions. You argue this. That is no finding in this case. Where is that issue decided interpretation that head office only and therefore set aside? No finding. Current single just simply says person should be given an opportunity to save his property, and rightly so. 300 Article 300A. The right to hold property. Why he should be deprived? Because he has taken loan. So the message is nobody should go to bank to take loan. Otherwise, he would be in perpetual trouble for rest of his life, even if he repays the loan. Right? This is the message. It's good for your business. If you trouble people like this, nobody will come to take loan. Yes, you will get it back.
Additional 5% solution. That is also granted.
We don't think that any case is made up. Thank you. Yes. Intra-court. Out of date of March 2022 passed by current single judge, by which a petition preferred by respondent number 1 in part 2A number 86/2022 has been filed by what? By on number 2 is Harish Kumar.
On 2 and 3 petition.
This is fund number 2 here. Petitioner this one. So
Single.
which I want to say bank has filed. Which appeal, Mr.?
480, 480.
480. Shri Bhagwati Cooperative Bank Limited. Herein after referred to as auction purchaser, namely respondent number 3 in the rate petition has filed WA number 477/2022 paragraph. Facts giving rise to filing of these appeals briefly stated up that respondent number 1 and 2 the extent of 25 lakhs of the committed default. There was a sale proclamation was issued for sale of the property of respondents 1 and full stop. The applicant in WA number 480/20 to be done.
477.
477/2022 full stop. An order. What was the order passed by the district? The opposite sale proclamation was challenged by respondent number 1 in a learned single judge paragraph. The learned single judge by an order dated 17th of March 2022 inter alia held that that respondents number 1 deposited the entire amount of rupees 25,61,400 which due to the bank with 3 months from the date filing of the petition. Full stop. The record was that forbiddance. Was inter alia of the opinion that every borrower should be given an opportunity to save the immovable property. The learned single judge therefore allowed the repetition part the interest of the appellant in WA number 4/2022 was also taken into account, and the amount deposited by appellant in WA auction purchaser, namely appellant in WA number 477/2022 was directed to be refunded along with 5% on the auction amount. In the aforesaid factual background, in continuation, right? In aforesaid background is a learned counsel for the appellant, learned counsel for the bank, learned counsel for the bank submitted that respondents 1 and 2 ought to have filed an application under Rule 38 within bracket 5 within 5 Rule 5 A. A is separately in bracket or 5 A's together? 5 within bracket small a of the rules. What rules? Society's rules to set a sale recovery officer. It is further submitted that the sale could set aside only on a ground of an irregularity. It is also such an application could filed before confirmation of the sale. It is that it is their contended that it is admitted that take into account the aforesaid aspect of the matter. The counsel There has also supported the submissions made by learned counsel for the bank and has submitted the order. This paragraph we have submission made on made by learned counsel for the applicants and have perused the record. Admittedly, after the filing of the petition, within a of 3 months, the entire amount due to the that is a sum of rupees 25,61,400 by the applicant before this court. Full stop. In fact, that the entire amount of the entire amount due to the bank has been divided by 1 and 2. Clearly demonstrates that this 1 and 2 had no not non-payment of the amount of loan taken by them, and they were not willful defaulters. Full stop. Merit single judge has also taken into account the interest of the auction purchaser and has directed refund of the amount auction purchase additional along sum of 5%. The aforesaid order is just and equitable, which does not fall and has been passed in the peculiar facts of the case, which does not call for the aforementioned reason. So these are, we have said that in the facts of the case, this order has been changed. For the aforementioned reasons, no case for interference with the order. Single doubt in the result. Appeals fail and are hereby pending interlocutory application do not survive. Accordingly, pending interlocutory are disposed of. Case is pending. Of 22 and 1 of 24. The application. Reasons assigned duly supported. We find that sufficient continuation in filing the appeal is made out. Accordingly, delay in filing the appeals are pending. The application. Let's see this one. Yes. Government advocate. Judge. Issue notice to respond. Can the BA? That's not the ground for it. Which right in law you have to seek a mandamus to acquire that matter? Simple. Okay. It's not time to proxy counsel. Very tough. Don't appear. It's our case, we will do whatever we want. Don't appear. Proxy doesn't give you license, not try to ignore it, right? Like right to life, right to education is embedded in under Article 21. That proxy doesn't mean right to ignore it. One number one.
There is no order against him.
No order.
The allegation is that they have sold the property.
There is no direction, right? We thought it simple. Think. Think. Only one.
As a decided the element of taking of the petition hearing is declared very common. Elements may be entered into the earlier records. With dependency of the original food, there is no need to clarify with the records. Listen, otherwise, you know, I have used the records. The office regarded
Parasite. Parasite.
as if our interest to observe the regulator is presently standing shall not take any advantage of the revised. They shall not get any third party interest during pendency of the suit. During pendency of the suit is concerned without being allocation. Third party interest is concerned without already entered into the achievement of the query. Disobedience of the court. I think the tampering of the regulator.
There is no direction.
Tahsildar has entered what?
Please send this with the RTC C2. C2. Very spite of that, we got the order of the letter records that the order of the Honorable High Court of Karnataka in WP 1270 of 2022 Kerala dated 7/2/22 pertaining to this survey number. There was a case pending in civil court in US until disposal of the said case. There should not be any transaction pertaining to the said survey. So that is not the single chapter is well related and liquidation is dismissed. This is related to restore the line in the revenue. Here we are so far as accused one is concerned, he has already registered agreement. The third party rates are created.
Has been filed for non-compliance of the direction contained in the order dated 7th of February 2022 passed in 0/2022. The operative portion reads as under quote para 6, right, page 23. Line below. Thus, it is evident that the direction has only been number one, not to alienate any third interest during the pendency of the full stop. There is no direction. Therefore, no case for issuance of notice to respondent number 2. Where accordingly, the contempt petition, so far as it pertains to this dismissed, issue notice to respond. Ready? Okay. Proxy counsel. Don't touch it. Now, what's your heard on the question of admission? So notice on merit as one of 2020. Okay.
6 and 8.
You are appearing for 6 and 8.
6 to
8. Notice on behalf of 6 to 8 is accepted by Mr. So notice to remaining. See how good it is to argue, no? The contempt you are appearing, good. If visits learned counsel for respondent has entered appearance, has already. So, trace one is granted. How much time? Weeks time to enable him to file Alat and compliance affidavit. Less thereafter. You should serve, right? You should be happy and obliged to him that he has appeared so moto in contempt, otherwise nobody appears.
Government advocate.
What happened? Issue notice to respond number 1. Notice to respond. Issue notice to respond number 2.
Kiran J, government advocate.
I beg to appear for the complainant, my lord. My lord, order under complaint is at 12, my lord. Page 12.
Issue notice to respond number 2.
Much obliged, my lord.
Issue notice to respond number 2.
Huh? 57.
Empty. Where in the direction retrieving you from this thing?
Auctioning.
Auctioning means right, not in this. But you said you are arguing 7. That's why we are asking where this appeal 2nd of August 22. No, but you said you are arguing 70. So we have. No, but no, let us in WA number WA 768. You have in the order dated 2/8/2022. We'll get to the other appeal later. to understand this. There is against order dated 2/8/22. And where is this? Where is the order of restraint in 2/8? Oh. Other case. No, what we are to 7/6/8/2022. You are carrying the order dated 2/8/2022. There is no order of restraint. Not this. You said 17, so we took up. As a matter of fact, we want to go 2/8/2022. There is no order of. You should act transparently, being a statutory body dealing with public. Right. Yeah. This is at page 41. Yes.
Sides. Corner sides.
No, that's fine. You have understood, right? Oh, in any case, not any site means what? No, you are. What is it? How points are there? He responded. All of them misunderstand. Then we will hear Mr. San. It appears. No. So all of them are entitled to corner sites. Fine. Just we'll hear him. Provided time of it appears like there's a very. 2017. Fine. Alters the plan itself. What is your possession of? What they say. No, so you claim entitlement to a lot for site, right? How many? What then? So then. So see, you won't. How would you justify a direction, blanket direction, not auctioning any site corner otherwise? How they have Why, right? Mr. Say, if they are engaging a senior counsel like Mr. Banjur Reddy, they are to survive. They are, but how this blanket direction? That's what we expect from you. A fair statement that this blanket direction can't be sustained. Right? Nothing should be done. That's it. Okay. All right. Three sides. Three sides. Fine, fine. So there are three sites for you in our layout, right? Okay. Sites. He did not say. He says. He says. Mr. Danu Reddy. He says Seri. He says. So whatever side. I tried to be modified with person, right? Fine. Fine. Very good. This rate appeal you are there. 820. Oh. Pick out a case before learning single judge, right? To get a direction like this. Yeah, but we can't grant it in a rate appeal in his appeal, right? No. If there is an order passed in your writ petition, tell us. Can we do it, Mr. Tell us, Mr. Prasad. Can we do it? You know, make an application there before single judge. Similar cases, they have been granted. Please grant me an order. In rate appeal, how can we enlarge the scope of this appeal? It's confined to Mr. Fanindra's crimes. A dispute between BDA and him. We can't get. We will dispose of your pleading application with the liberty to make an appropriate application before single judge. Not opposing. He is opposing. Yes. No. That's why we did not hear you this thing any further, and we thought it fit. Yes. No, that we are permitting, no, except three sites you do. All right, yes. All right. So we can dispose it of the appeal itself. All right. And his application also. Take it up. Yes. All right, yes, Mr. Yes, Mr. Council with Mr. P.S. Sachin, Council for the Council for Respondents 1 to 3. 2, 3, no? There are 3 petitioners, but there are only 1 petitioner. I will not stand. Why? All 3 are The numbers are indicated. I will not. All right. All right, all right. This intra from Mr. Learning Council for completing application. After hearing Learned Council for the parties, aforesaid IAS dispose of with the liberty to the implementing applicant to move an application, appropriate application seeking before declaring single judge. Like this intra-court appeal has been filed against an order dated 2022 passed by single judge.
58. Serial number 58, you have not filed impleading application.
Oh,
That is
Acha, don't delete. Don't send other case.
It's not at court.
Yes, this is you write. To try to see. The court appeal has been filed against an order dated interim order dated 31st May 2022 passed in WP number 20847 0847 bar 2009. We have heard learned senior counsel for the parties. After hearing learned parties, then line below. With the consent of learned senior, so in view of consensus arrived at between the parties during the course of the hearing, the consensus has met between the parties. 2022, the extent that BDA shall cites petitioners in WP number page 41 20847 part 2019 format WP number 2802 982 bar 2021 subject to aforesaid the BDA shall be at liberty to three sites in the corner sites in Arkavati layout. Line below, accordingly, the appeal is disposed of. They forget that there are three sides of this. Identify three sides you have said no. Shall reserve before that three sides. What is the sentence? Sentence.
Is therefore modified.
The interim order dated so and so is modified and shall identify and reserve three sites for petitioners in WP number so and so shall be liberty. Accordingly, appeal is due. What about 70? The identify and reserve subject before 30, right? PTA in addition shall inform about the sites reserved to petitioners. The aforesaid three did petitioners, right? Then it be subject to aforesaid shall be at liberty to auction. Accordingly, appeal is 70. Yes, Mr. Reddy. Now what 70? Ah. Yes. Yes. In this, there is no restraint order, right? And you see, Now we are dealing with 70. No, 58 is over. 50.
Also necessary for the period to all the each of the labor.
As of principal secretary is our state department. No, but you should volunteer, right? Yes. No, but there is no time bound direction, right? You should volunteer.
Transparency.
So therefore, transparent.
Respondents should produce the data and regards the across the year with the next date of next date is 2006 that has been granted. Okay, the project before the reporting
Yes. So you do it in respect of Arkavati layout first. The dispute is in Arkavati, web host all Arkavati. What is, but see, Mr. We understand that you want to say, you want to say that Lalit Singh has traveled beyond the scope of controversy and has given these directions. But for a statutory body meant for public, transparent, subject to Right to Information Act. Whatever you begin, whatever, see, nobody will punish you from this, but you do whatever you can, right? We don't expect you to do impossible, but you make a beginning, whatever, at least make something available, right? Not it. But
see the only for kindly see case
Fine. No, what does it say? So details of layout, whatever, I mean, whatever information is available, you web host it. What is that? But fine.
final notification in our. We have some photos on this case.
Yeah.
It's all being difficult when an there. This case comes up. When the hearing has six directions. Compensation paid in $9. Many of these are 6.89. Litigated details 6.89. 6.7 number of sites for the each survey number is prepared. There is another issue there. So we see it, right?
What is the mission?
We are trying to remove giving the detail. Function, the amount generated, what is the amount required for all those things? Let's record and that's whatever information. That's this about where itself is.
No, but this is still necessary to ensure transparency in the functioning of a public body like you.
This is not.
All right, let the learned single judge decide the issue confined in the writ petition, but we will direct that it be treated as a suo motu public litigation and we will monitor it now. Fine. Fine. Yes. Yes. We will register it as a public interest litigation and you file a response. That all this actions issued by learned single judge, we will issue in the public interest, suo motu public interest litigation. We are registering. Yes. Yes, we will. Yes, we will. Now we will deal with it. We are modifying the order, but we will deal with this issue now. Yes. And now we will deal with this, right? We are giving you notice, and everybody, you can also intervene publicly. So everybody you will have. Yes. Yes. This. Yes, we will register it as suo motu public interest litigation. This marks everybody's presence for reading aptitude, right? Then you write IA number. What is your IA, Mr.? Which IA? Which IA? Of 2020, what? 3 of 2020, heard on IA 3 of 2022. The aforesaid act, both of the liberty to be implementation seeking what implement the learned signal message, the analogy of the order passed by learned signal judge in similar cases with the aforesaid liberty, IES also is disposed of. The Bangalore Development Authority has assessed the validity of the order dated 2022, passed by learned single judge in WP number
0847.
WP number 20847 bar 2019. That's another technical issue. Like in each common order, you are challenging only in one. Remaining it stands, right? But maybe you should find technically PD in all. Not there. All right. I will don't know. Who examine that? Here comes the applicant submitted that the single digit was clear directions to the applicant where post all the pertain of the layouts formed by the Bangalore Development Authority referred in para 6 of the order. It is further submitted that while issuing the aforesaid directions contained in directions in respect of matters contained in para 6 of the order dated 2/8/2022, learned single judge has travelled beyond the scope of the writ petition. Full stop. Learned senior counsel for respondent has fairly submitted that the controversy involved in the writ petition is confined to the prayers made therein. Paragraph. We have considered the submissions made on both sides and have perused the record. The scope of the controversy. The grievance of the applicant in the grievance of the respondent in the writ petition which is pending before the learned single judge is in respect of site number 1525, right? Site number 1525 formed in Arkavati layout 7th block, survey number 74/1, Jaipur village 74/4, right? It's all page 79. Prayer clause, you can give the details. Survey number 74/4, Jaipur village, Bangalore. Full stop. Stop the full stop. Full stop. Mission made on behalf of the may be correct. Appears to be correct. Appears to be correct. Full stop. The order dated 2022 passed by the learned single judge insofar as it pertains to paragraph 5, paragraph 5, 6 is modified paragraph. However, we find that Bangalore Development Authority is a statutory body constituted under the Bangalore Development Authority Act 1976. The posted stop. The authority is a body in general. Full stop. The directions contained in para 26 of the order passed by the learned single judge raised an issue of seminal importance with regard to transparency in the functioning of the Bangalore Development Authority. Full stop. The authority need to state that the authority is enabled to Right to Information Act 2005. Full stop. Therefore, the authority is required to maintain transparency in its functioning and should upload all the and should web host all the details of the layouts. Full stop. However, directions which are contained in paragraph 6 and the 5 and 6 of the order. 6 of directions contained in details contained in para 6 of the order in respect of various layouts formed by the Bangalore Development Authority have to be done in a phased manner. Right? Full stop. We therefore direct the full stop, taking into account the issue of public importance involved in this involved, we direct the registry maintain to register this petition as suo motu public interest litigation PBDA at the first instance. PDA at the Bangalore Development Authority is Bangalore Development Authority by taking into account the assistance of the e-governance department as well as other departments at the first instance shall web host all the details, the following details with regard to Arkavati layer, right? So then following details. Do it right. So they're easy, right? Easy for you. These are within the thing, very easy. So following direction. So 6.1 to 6.19, right? 6.23, right? At the first Arkavati layer. Just before months. At the first instance, let us begin. Let it be a good beginning. First. Yes. You said that this order is modified, no? The order is modified, then say if the result appeal is disposed of, right? That intra-court appeal. Thereafter, the separate paragraph you write whatever. And then after 10 weeks, 10 weeks, 10 weeks, 10 weeks, 10 weeks, realistic, 10 weeks to enable the Bangalore Development Authority to report compliance with the aforesaid directions in respect of Arkavati layout at the first instance. Of course, we have disposed of the appeal. It's modified, order is modified. So then dispose of, before that you write, just a minute. Dispose before, just a minute. Before dispose, appeal is disposed of, you just now written before that one. Needless to state that the single judge as it is at liberty to deal with the writ petition pending before him. Accordingly, of course, these directions have been modified. The order has been modified. We have said order is modified. Okay. It's Mr. Reddy, it was a simple solution to a genuine problem. Yeah. Of course, with your everybody's cooperation, we could find an effective solution. They should be monitor it and see quickly. 59. Comment to look at. Say that power to compel attendance of witness would not include power to inspect. No, your submission is probably that power to compel attendance of witness include power to inspect. All right, he, as it is, he concedes that a debatable issue arises for consideration. No, he is also saying no. It can't happen. He is accountable. No. He is accountable to us first and then to the government. Yes. What do you say? What is the interim order? Stay of order constituting. So, we'll restrain them for taking any further action. Then there will be a committee, right? Otherwise, that one student, like the senior counsel correspondent said, nothing will happen, and so then other senior counsel to the appellant told us, sir, quite assuring they have come up with an order of reinstatement of these people this morning. Don't want like this. Week, wait for a week. You want to file objection? Sir, wait appeal. What? I am. Yes, no, not Indian counsel. 5, 4, 1 to 3 you appear, except notice on behalf of respondents 1 to 3. What? The nursing counsel you will appear.
Yes, undersecretary.
Then he should. Additional one. It has a high of 2022. Get that right. Any for pursuing permission granted to it in the year 2001 till next date of care. Immediately after 1 week. Yes. Oh. There is that. First 2000, right? heard on petition in ISO, right? One senior counsel for the petition. Yeah, appellant has done some division bench decision of Punjab and Haryana High Court in so and so versus so and so, page 1, right? Get the part info, page 1 of next 1560. It is accepted and recording is submitted. His notice has been issued in this case. Hearings are complete. We'll hear it someday, not today. Petition is at. Oh, let the petition be listed on 29th September 2020. There, no, it's already there. It has to be heard, right? Interim order. Yes. Yes, please. Yes.
Covered.
Which page? Page 53. Covered, right? Petition. We don't want it to be already. Don't want it to be decided. We should notice to the respondent. What to do, Mr. Vedana? We don't know when the with you court is in order in your favor, then also you want to argue. Then let they be satisfied. Let them respond. They will file objections. Notice. What? That's why we have issued notice, right? It's a strange case where the counsel for additional government advocate fairly submits his conceding in your favor. You are different. So we will have to apply. No, we will have to then apply our mind. Good. We appreciate your fairness. Thank you. Oh, Mr. Mahindra used to argue, concede. He doesn't want. He wants to argue. Don't concede, right? You don't know. Pertaining, and that doesn't make any difference whether you pay the fine or don't pay the fine. We don't know. I mean, we will hear you. Yeah, but on. We have issued notice. We issued notice. Notice on behalf of respondents is accepted by learned government, additional government advocate who grace fund is granted. 3 weeks time. We will file objection. Next. Yeah. Okay. 22. My copy of the annexure is dispensed with. The result I indicated. We have issued notice to everyone, right?
How much of a beer is? $54.
By next date of hearing, they won't. Bit of it.
It's a direct from the finally. So they are actually
Find out. Find out. That's why we issued notice. Issue emergent notice. Fine. Date. We don't know when it will be served. You tell us. You know.
WP number
It will
ಎಷ್ಟು
be
ಇದು?
served.
ಸ್ವಲ್ಪ
I know how.
ಇದಕ್ಕೆ
6 September. Just on 26 September. Yes.
Last one matter, number 28.
Doesn't matter, sir. Fast. Madam, just 2 minutes. The matters will take.
38. 38.
38.
Pawan Kumar MN. H. Chaudhary.
Yes. Okay. So he is a complainant, right? And in this thing, we are told that in pursuance of the direction issued by Lawrence, been implemented. You have amended, right? No. Why? What? I mean, tell us why he should not be. You should, on the other hand, welcome everybody that please come and join so that this Vikram Uligol will initiate independent proceedings, challenging that this order does not bind me and all that. And so he will file another complaint case. We heard.
I see the emails were sent from a different email ID. That is from one Shankar ID. And you will see it is not so visible.
Yeah, what is the complaint against you? Paper. Yes.
And that is
Take more than 2 minutes, right? To conclude whatever. 127.
And he made submission that he was not a resident. He produced this tenancy agreement. He said this notes that Lester himself is a tenant under the owner. And kindly see this document, kindly see the price rate. November 2nd, 2017. Finding of the document is done on November 2nd, 2017. The agreement is dated 1st of May 2018. What was franked was a blank sheet of paper. Under the franking rules, only an instrument can be franked. A blank sheet of paper cannot be franked. That is the operation we have taken. On the basis of this, there is a thereafter in the present proceedings, he changes his address. He changes his address. 71. He also not residing in page 131. Another person is holding million words. Therefore, I have produced the document 131. Is the petition. Residing in 570. The same address is shown now. He is residing. Kindly page 132. In a firm lords, in a company lords, they are all partners. They are all partners. Now, in fact, he is not a resident of the locality. He is not even residing in any of the addresses, notes, two addresses that we have. He has produced note this fabricated document with the learned signature in the earlier round. Taken up so there are notes now. He says he is a complainant. Now, complaints that he had produced for the learned single child, the earlier round of litigation, and he sees the complaint that he has produced. This is that page number 105. The email to somebody else. At page 105, yes. Page 106, that is slightly page 106. And it's in notes, provided message is from Rangareddy, subject regarding illegal constructed permanent work law to contact BBMP. So, this email is from Rangareddy. Yes, my case. And not only that, notes. It's not a proper and necessary part.
But you did not bring it to the notice of learning single judge on this. Because there's no in the order, there's no mention of this.
That's the exact terms in the regulation. Some sentences Supreme Court. So, supplication. That's an exact order. Remember that it is a court by judgment. Even in that case, the Supreme Court is an intervener. He cannot be permitted. Even if that case is followed, he could adjust to an intervener. The rights of the intervener and the party respondents are totally. How much my submission is? He is not, and he is all affected with the learned single judge in earlier proceedings.
So, who are your opponents having if he is left out BBMP? What name? Okay. It's not a public interest litigation. He cannot act. The BBMP court has taken action against me. I have gone notes. I have filed a petition against the BBMP. Now, he was my neighbor. I understand he's supposed because there is deviation with regard to setbacks, right to his ventilation issue and also his lighting issue. Taking advantage of he is putting struggling a document just deciding. He actually filed an affidavit before stating that he approached us for the purpose of purchase of this property. When we said no, he started this. His affidavit note is on. But he is trying not to.
All 11 page.
I had since then actually look at page 134 paragraph. Actually looking to purchase the broad side of the house in the
Para 3.
occupy the premises only from 2008. Only as he had to clear certain income rentals. But in his tenancy, his agreement was specified on 31st October 2015. This document was duly franked on 2nd November 2017 and subsequently executed on May 1, 2018. I have advanced the sum of rupees 1,000 as a token advance on the day of slightly demonstration. The sum of the police is not the owner of the premises. He is that he himself is a tenant. And this agreement looks under the banking rules. And agreement, the bank's 2 rupees paper notes cannot be franked. It is an instrument only which can be franked. Franking notes took place on 2nd of November 2017. The agreement could not have been printed in May 2018. It is a fabricated document. I am for the fine notes. I have since then actively looking to purchase a plot site or an house in the locality. Properties I came across this property, we constructed. In fact, we did not agree to sell the property and we started doing this. But my only submission is that order should be followed. That is of the interview. It's for completing applicants there committed to complete themselves as interviews. The notes also increase notes as an interview.
I believe, take this.
Yes, we heard that from. You wanted to purchase the property, which it didn't sell, and that's all. No, but you told they have lost interest. Doesn't seem not at all. I mean, they have engaged the senior counsel and he's arguing. He has so much to say about you. Huh? You were telling us first round.
I'm not saying
Oh. We thought that you are giving us this thing, some respite in the late hours of the day. So, but all right, alternate suppose. We'll deal with.
The point is, for some other means to an end, rather as an entity. If it is really public spirited notes, I understand if you file a public that's wrong by the and the very issue is given. And maybe he is my neighbor, he doesn't want to come out. What is happening? Therefore, if somebody is reading action, let them come out. Only as an interview.
Yes, please.
consideration is whether I'm necessarily proper market. I'm not a necessarily proper market. After considering the not going all the issues that I heard, I live in Bangalore and live in Delhi. Am I necessarily proper?
Or Pune also, right? Pune also. Yeah, yeah.
This is how citizens oral money. They could be anywhere. They did not give a neighbor. Such a case, this is situation where there are various whole as a
And you intend to buy his property, right? We can see. Yes, Mama. He None for the applicant, given that the matter is called in sitting room, awaiting appearance. Counsel for the applicant hearing is deferred, please start the meeting.
Junior had appeared. Junior had appeared. 49.
None for the applicant. Hearing. Yes, now. Yes.
Second respondent. So now, some things which are not do.
First.
Its executive power. Range. Conduct an inquiry. It's not the. The petition not aside my objection. But court in order. Hang on, 290. On order dated 5/11/18, after the High Court held it. If you recall the order dated 28/4/16, after the division bench High Court, the aforesaid retreat. Issuing notice, following directions were issued to the High Court in the order of 8/4/16. April, came up with the offer. Union Bank of to the refill. Regulating their business. Big opportunity. Influenced by the tendency of these regulations. These regulations 1 week after the regulation report after elections. And to put the matter, typically the reason of it that you have no to resist the going. Constitution, please, not about holding. Definition number 526. Instance of within that. My order date is 5517. Directed conduct of it. And gave rise to written number 46 for the division the stay of proceeding. If the exponential increase the execution the order 28 votes. Maintain the to the order going into the question of the High Court by order of Section 617. Which was sought to be recalled is 28,450. Defined IA number 2 of it. Did not pursue it, did not till 2019. 19. Here before Lord different bench and on the justice. It is not there. Yeah. Why? They participated in the inquiry before they pursued this application. If I may continue reading. The High Court disposed of the interim application and later by its order 25/11/19 dealt with this controversy arising with respect to number 4. The matter concerning maintainability of the expedition go to the root of the matter. Consequently, directions issued to the Chief Secretary will depend squarely on such stability. We direct the 27/6/19 is prescribed. IA2 is restored to be disposed of. Till the disposal of IA2, effect and operation the order dated 28/4/16 shall remain stay. Consequently, the consideration bestowed by the Chief Secretary and the resultant order of bench shall also not be given. In the matter regarding maintaining operation continues party selected. Now to facilitate early disposal of the matter, parties shall appear. Question is this: what is now? Page 13 now, 30. Page 13 now, appropriate redirection to the third respondent to regulate the second respondent. All other parts of the state pending the passing enactment. Alternatively, to blame scheme. Page 30. Page 30.
Amended.
The prayer in the expedition.
Next paper.
Page 30.
Yes, we got the unamended. Yes.
At 5 case it was unfortunately retired to third respondent. To regulate the second respondent, all other parts in the case, leading the person alternatively, the claim scheme to regulate parts in general, and in the present context to regulate the second respondent having regard to the issue direction, including the first respondent. Direct the sixth respondent to order investigation and evasion of tax, institute action against the offender.
Does it receive any sort of granted aid or something from the government institution, whatever?
But the Karnataka Hindu religious institute
This mutt receive any granted aid from? So maintainability in the context of that, how it is amenable to writ jurisdiction like that. What is? Like, I mean, this, it could be one of the arguments were just struck to us. One of the arguments could be that litigation at your instance cannot be maintainable. Other could be a respondent number 2 itself is not amenable to writ jurisdiction of the court, something like that. What is
yeah, somebody else had filed a report, and that petition got dismissed for default. They say that person, the one who is behind this, before having gone to state has control over these which have been the subject matter of constitutional debate. I'm not in this.
Okay. One. Merci.
There is an earlier pre-independence legislation law for the Mysore Religious and Charitable Endowments Act of 1927, which has been repealed in this later act. So far as Hindu religious institutions are concerned, but evidently the actual challenge on the ground, but it is something. Yes. But the matter went before the Honorable Supreme Court. Honorable Supreme Court passed certain interim orders and made it clear that the judgment will remain stay, and the enactment can continue to operate. Not contain any problem. Against but so it has lawmaking
Yes.
power.
We'll have to that import terminus.
If it has made law, then it is law. It has not made law. Its power is can exercise law. It's available. Not in this case. It is alleged and the state will not acted in of its power, its power. They are not on the civil servant I produce some order. What's an institution? It is exercising Article 162 power. Now, when these serious allegations are there, why is it that the state is handing him with kid gloves? That was the frame of my petition. And what if the Lordship should now permit me, Lord, just to show a few of the allegations, not everything is necessary. Just to show to your Lordship that the allegations are grave, they are very serious. Will the state allow an institution of this kind to be headed by a person type of character? If the state feels not that nothing is to be done, then it can take that decision, but it can't just sit quiet. In fact, after the order granted to respond before, the chief secretary required it to them. They raised an objection on maintainability. That was overruled. Then they filed a writ petition. They wanted to stall that. Then not the matter went forward. The chief secretary, it required the deeper directed the endowments commissioner to exercise and come at the state. At that stage, not the second round of petition came, state, and then not it remained like that. Till they pursued this. Yes, after the order was made with the Honorable Court. And I must say, Lord, to the best of my recollection, there was no request made to the court. Say that please decide this maintainability issue. That's a very CH-2 was listed on 28 days. That's what the order says. 28 days it was listed. And the Honorable Division Bench not by the order. There's an interim made. And query order. Take a decision. It's a question of recalling the order now. To the observation. Even at that stage, submission was made this question of maintainability. However, my Lord, I'm not going to say before the Honorable Supreme Court, persuaded the Honorable Supreme Court to pass an order saying question of maintainability is there. That should be first taken. Now, the Lordships may not see it. Allegations against the House.
We continue to mark the charges on account of paucity of cannot be concluded. Submission for future cases concurrent blame severe count. It could not be concluded. List for further hearing.
Lord, may I make one submission? Serial number 65.
Seven.
Serial number 65, my lords. My lords, may I make one submission?
This is eight.
My lord, may I make one submission, my lord? Serial number 65.
Hey, you should have the morning at 10:30.
No, my lord, I didn't want it.
You are
Can we
waiting
have it next week
52,
on the 15th?
45 pages.
15th or 16th, my lord?
Huh?
On the 15th or 16th, my lord?
See him. Can you see him, Mr. Rao?
I am,
Very much.
I am,
He is very much there to oppose everything.
no, not everything. All,
Yes. We definitely appreciate that. So, Mr. Let it continue tomorrow, Mr.
No, my lord, tomorrow it requires physical hearing because it's a heavy matter.
Please
Your
come
lordship
tomorrow.
heard it 2 days.
Huh?
Your lordship may have it next week, that is on 15th or
In
16th.
the case we remember you told us that it has 7 boxes.
I know.
Huh?
Your lordship released it from parted.
Huh? Parted?
no.
Your now I have become parted.
We won't release.
my lord,
That was released from parted.
next Monday it may be heard, my lord. Next
Monday I am in
Monday.
the Supreme Court.
All
Monday,
right.
in the very same case, I am in the Supreme Court on 12th.
All right, 13th. We will have it on 13th.
I can't come back like that, Mr. Barao. I am also getting old.
Oh,
And I
good.
become, though the
No,
case
no,
is
no.
parted, I have also become parted.
14th. Which?
15th, my lord.
Huh?
15th September.
15th. Mr. Rao, 15th.
Ask your lordship, please. I mean, I cannot, he says he is old. I cannot, my lord.
No.
I am not as
So
young
I-
as Super
Everybody is young.
He is pretty young.
Party presence.
I have got one submission, my lord. The records of the single, that is the writ petition may be put up, my lord, because my statement of objections and all that is not there. Writ petition records may be put up along with this.
We hope that it can be handled, right? And not to be kept in boxes, etc. As Mr. Kasturi has been telling.
But writ
should be
petition
one of the
record may
box.
be put up.
Along with records of the writ petition on 15th of 15th. Yes. Tomorrow. Say, tomorrow. Yes. Further hearing tomorrow. 8.
Obliged, my lord.